May I permit to
Madam, may I have a lordship's kind mention, leave to mention, Madam, this is the extension.
Start. I think I cannot take further mentioning of court number 34. Tomorrow is original site day. Day after tomorrow is my last day before the vacation.
So this is group 1, because the file is lying here.
I would just like to say that court number 34 shouldn't wait. No. I'm sorry. No further. No further matters can be taken. No further mentioning of court number 34. Yes, group 1 and group 7.
Madam, this is, Madam, I have mentioned with notice. Madam, file is lying here, Madam. In spite of the matter is not being listed. It is one file is being received by on 6th of September.
Motion.
No, Madam, extension of interim order.
Give the number. Didi, dekhe neven to. When is it expiring?
Madam, 30th. Because I upon notice I mentioned yesterday, day before yesterday, Lordship was kind enough to extend one matter, 3 analogous matter.
You were asking, saying 2 other matters are there.
Yes, 2 other matters are there.
Didi, dekhe neven.
কালকে আমি ডিপার্টমেন্ট থেকে খবর নিয়েছি, কম্পিউটার দেখে ওরা বলেছে এই দিনকে এসছে। এই জন্য আমি না এটা লিস্টে রান করছিল না, একটাই মাত্র মান্থলি লিস্টে ছিল, বাকি দুটো ডিপার্টমেন্ট থেকে বলেছে কম্পিউটার থেকে যে এখানে এই দিনকে রিসিভ হয়েছে।
Application is
What application?
Yes, madam.
What application is it?
Well, after disposal of the read petition, one mistake in the call title has been detected. That's why I have filed
one mistake for correction. Correction to be mentioned. Yes.
I seek my lords kindly to move this application read petition. The lordship kindly grants me a group 1 mirror.
What is your urgency?
A eviction notice under Rule 3(1) of the West Bengal Government Premises Tenancy Regulation Act has been initiated by the government. Admittedly, this act does not apply eviction when says so. Now, otherwise, without jurisdiction.
Why don't you file and come back? Give the number. I'll get
tomorrow. Unless the leave is granted, the matter will not be listed tomorrow. I am serving them. I will serve other side. I will serve the government.
When is the date?
Date means 19 September. This has been issued to me. Deeply obliged.
Tomorrow leave granted.
West Bengal Government Regulation of Tenancy Act I am going to be evicted by application of post today, and the notice I gave at the next day. Yes.
Tomorrow 10:30. Tomorrow morning.
That's the difficulty. They are saying that they are coming to evict me at 8:30 today in the morning because of the rain. Possibly they have not arrived here. Once the rain stops,
2 p.m. Can you put the other side on notice?
I have asked for dispensation of service for a day.
My lord, may I have your
kindly to mention my extension of interim order. Extended interim of 30th of October, 13th and 13th of October.
Group 1.
Group 1.
I have extended till 30th of October.
13th of October, madam. 13th of October is a
with your lordship's leave, Millard, I appreciate what has fallen from your lordship.
I'll not get further time.
I need leave to file this application, otherwise it cannot be filed.
What is your urgency?
Yes, Millard, an interim order was passed directing the restricting the investigating agency from taking any coercive steps against me. Millard, thereafter we are senior citizens residing at Delhi. A 41A notice, despite the protection by this Honorable Court, was given to us. We replied that kindly permit us to do it on the virtual platform. Again, another notice has been issued saying that you have to be present physically on the 5th. Millard, we have filed an application praying for modification of the earlier order passed by this Honorable Court, permitting us to participate in the 41A through virtual platform. But it cannot be filed. Millard, I don't know so
leave granted.
Be granted.
My lord, under compelling.
Leave to file.
My lord, may I have your kind.
Group 1.
My lord, may I have your kind.
What is your urgency? Because these 2 days. Matter will be taken up only after the vacation. If you still want to file, you can. After vacation.
Yesterday, after taking the lordship's leave, the matter was supposed to appear to be matter is getting the different filing that is not my matter. Maybe after that, 1 year, the notice of
কোনটা? আপনি different file বলছেন তো? ওহো। আনেনি, অন্য ফাইলটা আনেনি। ফাইলটা কোথায়? The other side is there. Can you put the other side on notice? Please wait, let me see. Please wait.
My lord, under complex circumstances, my lord, under complex circumstances, my lord, I'm mentioning one matter. My lord, I have already mentioned the matter on Friday, my lord. I mean, CRR, my lord, got the urgency.
CRR,
Yes,
group
got the urgency, your lordship
court
was-
number 34 mentioning will not be taken any further. I have already said.
Mentioned, my lord, on Friday. Your lordship
Nothing
was pleased
further
to
can be
allow,
done,
my lord.
madam. I'm sorry.
My lord,
Tomorrow is
my-
original
my
side day. It
submission
will not
is
be
that, my
possible.
lord, the file is in court. Your lordship was pleased to allow, my lord. My lord, but it is not appearing the matter which. has
There
been
are
filed
hundreds of
after-
mentionings which are still lying here.
My lord,
It is
the
not
matter which
humanly
has-
possible for me to take up all the
The
matters.
matter which is filed after me, my lord, that is appearing in today's list, but my matter is not appearing. That is my submission, my
I'm
lord.
sorry if that has
That
happened.
is
I
in
can't
the
help,
court,
madam.
my
I
lord.
cannot do anything
If possible,
further.
my lord, your
No
lordship, that is-
further matter will be listed from court number 34. Please
that
do
it
not.
has already been
mention.
mentioned.
My lord.
Your lordship-
Maybe there are several matters which are
taking- my
mentioned,
lord,
but they are not.
Otherwise, matter will be infructuous. Your lordship.
Sorry,
file
madam,
is
not
here,
possible.
my lord,
I'm sorry, not
My lord,
possible.
Lordship.
taking your lordship's leave, my lord. This is a matter of 34, my lord. Urgent,
34,
I'm
please do
my
not
lord,
mention.
urgency is, my lord,
Please do
WPA has
not
been issued
mention
simultaneously, my
34 matters because there is no further time
my
for me
lord.
to take
Warrant
up.
proclamation has been
I'm
issued
sorry,
against a
I'm
journalist, my
sorry.
lord.
Yes, any group 1 or group 7 matters to be mentioned?
Not matter, my lord, extension of interim order, my lord. Last Friday, my lord, I already mentioned this matter, along with the notice, my lord,
When is it expiring?
30 September, already expired, my lord.
Give the number, give the number.
Another part is the, my lord, ABR of your court officer, my lord. It's very rough, my lord. Very rough, my lord. Yesterday, 4:45, my lord, has come to court. Extension of interim, what is? Don't say anything, don't use everything. This is the behavior.
I'll speak to the court officer. I'll speak to the court officer.
Yes, my lord, it should be allowed, my lord. Already expired, my lord.
But one thing you must also understand, I am in charge of
But
court number
only-
34
only, my lord,
also.
Bengali language
So
only
there
said,
are-
my lord, madam, এটা কি হলো? ম্যাটারটা মেনশন করেছিলাম কি হলো?
There are several, the
Okay,
court
my lord.
officer is
Okay, my
also
lord.
under
Yeah,
pressure.
Yes.
I will speak to her, but
Only,
you
my
must
lord, I am
also
saying,
realize that the
madam,
court
কি হলো,
officer is
madam?
also under pressure.
Nothing, my lord.
At times,
Nothing.
sometimes from your side also, sir, I'm sorry
No,
to
no,
say,
my lord.
there
Wrong
is
information, my lord.
strong language used.
No, my lord, nothing.
So let
Only,
us
my
see,
lord, said
let us
this
see.
is- এটা
I
কি
will
হলো?
only request both the parties to have some patience.
Without this, my lord.
What is this that you're giving?
Extension of interim order, my lord. Already expired. on
Have you
30
put the other
September.
side on
Already
notice?
mentioned in Friday, my lord.
Have you put the other side on notice?
Yes, my lord.
Lordship, it's a code 34 matter, eventually, Lordship. Code 34 matter was,
For matter,
no,
I will not
Lordship,
hear. I have not allowed anyone.
but Lordship, the
Sorry,
matter was mentioned yesterday, eventually, Lordship, and your Lordship was
On
pleased to.
pension matters, it's difficult to take in the list because there are hundreds of matters which are being mentioned. I cannot possibly take up all the matters, isn't it? You have seen the amount of mentioning that is made. Please wait up for 2 more days.
May I be permitted to mention, my lord, an extension of application, my lord.
Which court?
My lord, court number 34, my lord.
34,
My
please.
lord,
So why are you
my
not
lord,
listening,
despite-
sir?
Despite the pendency of this application, my lord.
Sir, I will
audit
not
of
hear
additional
about
application,
court number
my lord.
34 matters any further.
Petitioner would-
Yes,
I mentioned this matter last week, allowed by.
court number 34.
34, my lord, I was come, my lord, my.
There are several matters, sir, where file has come, mentioning has been allowed, but it is not, I'm taking up matters only for 1 hour. Because I sit with a list of more than 400 matters. So it is not always possible, sir. You must understand. Please wait for 2 more days because tomorrow, day after, I cannot take up court number 34 matters. Because tomorrow is original side day. Day after tomorrow is my last day before vacation. I'll be leaving for a circuit bench on Monday. So it will not be possible for me, sir. Please.
My
I'm
lord,
sorry.
Your Lordship, kindly to mention a group 1 matter, Your Lordship. I had mentioned this matter on the 12th of September, Your Lordship. Your Lordship had allowed it for upgradation, Your Lordship. I mentioned, despite that, it hasn't come in the list as the updated matters, Your Lordship.
Have you put the other side on notice?
Your Lordship, it hasn't come in the list.
That's why it has not come.
Your Lordship, it's already there in the list, appearing as 197.
Mentioning has to be done upon notice to the other side. That's why it has not come up. I have given strict instructions that without notice, no matter will appear.
Apologies.
And I am praying for leave to mention upon notice, my lord, for inclusion in the list under group 7, my lord, new
What
matter.
is your urgency, sir?
My lord, it is a matter where my goods have been put into jeopardy by the stockist, my lord. I had imported some goods, but that they had kept it in godown, and thereafter, without my consent, without my knowledge, they have removed the goods from there, which has led to the destruction of the
Have you
goods.
put the other side on notice?
Yes, my lord, I am mentioning upon notice.
Give the numbers. Group 7, Didi.
Yes, my lord.
Yes, call the days list, please. Item 1. Yes, who is appearing for the state? This has wrongly appeared. This should be 2023, not 2022.
All these are my. Therefore, I am in the impression, my lord, the matter is not appearing, but my learned copy.
So if you give consent, let me take up this matter because
Yes, my lord.
2023 matter. Because I believe there is some urgency. So by consent of the parties, I'll treat this on days list. Yes, and take up the matter.
Petitioner.
Only the state?
The private respondent Paraspanata is appearing.
I could not receive any Bhokaladama because it is not yet been reached to my my lord, my client, my lord. Because this is the private respondent, I am appearing in another matter, I am appearing on behalf of the private respondent. But this is absolutely separate matter. I have to take the Bhokaladama separately from my client. I have to take separate Bhokaladama.
Yeah, let us hear the, what is
The
your
advocate on
urgency?
record tried to serve yesterday.
But I could not get the Bhokaladama. I can only accept it because this is separate matter.
May I serve you a copy? May I serve you a copy?
I undertake to Bhokaladama.
Yes.
Yes, Malata. Petitioner Malata constructed a tea stall of 95 square feet just beside the PWD road. But initially it was under the Jela Parishad. Till 2021, the government report shows that it was under the Jela Parishad. In the Jela Parishad, there is a provision for long-term lease or short-term lease in favor of any persons who makes applications. In the year 2021, I made an application, but that was not considered. There were several litigations.
You made an application for what?
For a long-term settlement or short-term settlement in favor of the petitioner, because the petitioner is doing his business of a tea stall of 95 square feet only without obstructing anybody, anything, for last 30 years and paying tax to the government. That is page 22. Once, can you see the report of the video? Page 22. Report of the video. May I read, Malad?
Yes.
In connection with the subject mentioned above, this is to inform that as per inquiry found that the plot number such and such, motor such and such, accordingly field inquiry has been done. It appears that as per record of rights, total area of LR plot number 2548 is recorded as 16 decimal in favor of different 16 numbers of riots. As per inquiry report found that in part of LR plot number 2603 of the 3276 in Mauja, Bishnupur, jail number such and such, Yusuf Sheikh and Yusuf, son of late Yasin Sheikh, erected a tea shop measuring 96 square feet 31 years ago while encroaching land of Jila Parishad. This is the report of 2021 of the LR plot number such and such. This encroached land located partly in front of LR plot number such and such. As per verbal report from the people, Yusuf Sheikh, son of that Yasin Sheikh, has been running the tea shop for 31 years approx.
Yes, but this is encroachment.
Yes, but I am not encroachment. Since there was a provision of settlement of such type of land in the Jela Parishad, I applied. There are several litigation ultimately went up to the appeal court. In the appeal court, the government filed a report said that this land has been transferred from Jela Parishad to PWD. So in case of the PWD, there is no such provision of long-term settlement. Now, I made an application since I am doing this business without any obstruction from any part. In terms of the section 8 of the Highway Act, they can consider
relevant portion is is at page 73.
Three.
Last but one paragraph. In the above, after considering submission of the parties and facts of the case, being the district magistrate South 24 Pargana, I am of the opinion that the writ petitioner, namely Yusuf Sarki, is not eligible for long-term settlement under the rule 238 read with 215 of the West Bengal Land Reforms Manual. The representation of the writ petitioner dated October 11, 2022, hereby considered and rejected. The executive engineer, Public Works Road Directorate may take necessary action on the basis of the application of the writ petitioners as per law. Now, without considering anything, without taking any decision, straight away they serve the notice of demolition. Just one day earlier. Next page, page 74.
Give me. 54.
And that too, the assistant engineer, direction upon the executive engineer, and this demolition order passed by the assistant engineer, who has no authority. My only plea, Honorable, let me consider my
Who
representation.
is the private respondent?
Well, I am not, my lord, what is happening in this
He is the
matter?
private respondent is the adjacent landowner.
My lord,
He is no way affected by.
My lord, what is
no
happening,
way
my lord? There is a gross suppression of the material fact. In the writ petition, they have annexed note. My lord, initially I filed a writ petition with this honorable court alleging the encroachment of the PWD land. Proceeding was initiated. My lord, the subdivision order passed order. My lord, holding him, he is an unauthorized occupier. Plus, my lord, that is, my lord, they challenge the order in the appeal. My lord, during the pendency of the appeal, he filed an application for long-term settlement. My lord, the appeal was one pending. He moved to writ petition before this honorable court. Honorable court directed the DM to district magistrate to consider. District magistrate initially considered and rejected, page 54. Against the consideration order, they again filed a writ petition. The matter went to the appeal court. Appeal court directed DM to consider and DM again considered. And that was rejected on page 71. And my lord, in the meantime, my lord, the order on the appeal, section 10(4) order was appeal, my lord, has dismissed. This order has not been challenged. The appellate order has not been challenged before your lordship. My lord, what they have want, my lord, this order of the appellate authority is reached its finality. Now today, my lord, the notice was which is issued, impugn notice, and that is the consequential follow-up steps of the dismissal of the 10(4) appeal. My lord, today, my lord, they want initially there, it is their pair from the day beginning. My application is not paying consideration, let them stay of the proceeding. My lord, the court directed, considered, DM considered, rejected. Again, my lord, they come before this honorable court, challenging the rejection order of the district magistrate. District court further directed to consider in the point. Again, the DM considered and rejected. My lord, now, my lord, this is the third time they, my lord, again take the same plea. My representation is still pending, so not to take any steps. My lord, you will also kindly see the order of the 10(4) appeal. My 10(4), my lord, that was passed on, my lord, 27th of February 2023.
The presentation was filed on 29th May 2023.
That is subsequent representation. Initially, there is a two representation. Before the matter, you will also kindly come to page my lord 54. First order of the my lord district magistrate, page 54. Kindly come. At the time of hearing, the advocate of the appellant stated that his client appellant has been possessing the land by running a strips of measuring such and such, which is situated at Munja Bisweswarpur Dagnama such and such, and more than 30 years. He prayed for the client representation dated such and such October 11, 2022. There is a representation regarding this long-term settlement for his client occupied should be considered as per section 215 of the West Bengal Land Reforms Manual by the authority. The advocate appearing for the private respondent submitted that as per West Bengal Highways Act, the appellant is declared as an encroacher of the government land. He also stated that he occupied the land falls under the definition of the government road as per section 2, subsection BB of the West Bengal Highways Act 1964. He also submitted that the appellant is not eligible as long-term settlement under section 250 of the and section 219 of the West Bengal Land Reforms Manual 1991. He submitted that section 222 deals with the cases where the collector shall identify suitable plots of land for long-term settlement, keeping in view of the long-term development of the urban and semi-urban areas. Therefore, the applicant pair for consideration of the representation for long-term settlement under the apportion is not maintainable. The Secretary Jilla Parishad is directed to submitted the road in question is lying maintained by the PWD. The block land and environment officer is the appellant is the encroacher of the government land and not eligible for the long-term settlement. This is the first order of the DM. This order was challenged in the writ petition. the court is directed to you should consider in the light of the, my lord, the section 209. My lord, that is, and now the second order, my lord, that is the distinguished in terms of the revision bench order. My lord, page 71. My lord, your lordship, kindly come to page 71, the order of the district magistrate.
Yes.
My lord, page 71, and my lord, kindly come to the page 72. The assistant 72, my lord, second paragraph from the bottom. Assistant engineer, starting with the word assistant engineer. From the bottom, my lord, I am not. Assistant engineer, public works department, director highway submission that the land in question is handed over to the public on such and such date. He also submitted that the executive engineer, Diamond Number Highway Division, 500 dated that is requested additional district magistrate for record the correction of that. The peruse that, my lord, and my lord, you will also kindly come to my lord once, my lord, page 71 once. First, page 71. My lord, I am just reading at the time of hearing the advocate of first paragraph. Pursuant to the notice of hearing, advocate on behalf of the appellant, namely Sarul Mullah, well, there is my client, and the risk petitioner Yusuf Sheikh, assistant engineer, Lokhianpur Highway Subdivision, the office and the officer in charge long-term settlement land section, district South Chittorgarh, block land and is appeared and signed the attendance sheet. At the time of hearing, the advocate of the appellant stated that the gist of the case is that the lead petitioner, namely Yusuf Sheikh, without obtaining permission from the competent authority, made an illegal construction over the PW road, just informed his client's landed property, blocking the egress in case of the appellant. The appellant Sauril Mullah filed a writ petition being such as such. But the said writ petition was disposed of by the audited one. This is my writ petition, 4th of February 2021, passed by the Honorable Justice Ravi Kishan Kapoor on Calcutta High Court with the direction to the subdivision diamond number to consider the representation of the representation. Pursuant to the aforesaid direction, proceeding under the West Bengal Highway Act were started. Subdivision was the diamond number passed an order for removal of the illegal encroachment of the said Yusuf Sheikh under section 10(3) of the aforesaid act. The said order of the Yusuf Sheikh under said order and said it is under section 10(4) of the aforesaid before the district magistrate South 24 Parganas. During pendency of the appeal, well, kindly see, during pendency of the appeal, the Yusuf Sheikh first time made an application before the authority for long-term settlement in connection with the illegal occupied land, and he was subsequently filed a writ petition in messenger for grant of long-term settlement under section 290 and 220 of the West Bengal Land Use Act. Well, this honorable court directed by order 17 called the affidavit from the concerned parties, referred the matter with the regular bench. Being agreed by the said order, again filed an appeal before the division bench, being mat number such and such. The said appeal was disposed of with the order dated 5th of December 2000, passed by the honorable division bench of the Honorable High Court, with the direction upon the district magistrate to take a informed decision in accordance with law. Pursuant to the said direction, the Honorable High Court district magistrate by order dated 17th of February 2022 disallowed the representation of the Yusuf Sheikh and observed that Yusuf Sheikh is not eligible for the long-term settlement. Being agreed by the aforesaid order, again filed a writ petition before this honorable court, being WPN number 7184 of the 2023. Said writ petition was disposed of by honorable justice with the direction to district magistrate for considering the representation name of the writ petition, namely Yusuf Sheikh. Being agreed by the order, his client filed an appeal, being made in
Section 8 application has not been considered.
well, section 8 is subsequent to the everything was rejected. Well, every time when the order was passed, the kindly as on today, the 10 for appeal, they are totally separate to proceeding. One is section 10 proceeding, one is pair for long-term settlement. My lord, he has clubbed, he cannot club to
Section 8 and section 10 are connected.
my lord, kindly appreciate, my lord, when my lord, the section 10 for order was passed on 23rd of February 2022. After lapse of time, this order was not been reached, not been challenged. It is reached its finality. Now, my lord, otherwise, he can file an application and my lord, stay the order of the, my lord, the section 10 for appeal. My lord, this notice was, my lord, this notice in conscience of the 10 for appeal. When the appeal was rejected, my lord, there is no other procedure but to recover the, my lord, the possession. My lord, today, my lord, he has filed an application. My lord, tomorrow, again he filed and rejected. Again he filed a writ petition. My lord, day after tomorrow, my lord, the order was rejected. Again he filed a writ petition. That was been going on since 2022. He initially represented.
If the law permits, can you stop it?
But my lord, as on date, my lord, the order under the 10 for appeal, that was not even challenged.
That is not challenged here also.
They are also not challenged. So, my lord, 10 for appeal, let them consider in accordance with law. If the authority concerned is decided he has been eligible, let him be granted to him. But my 10 for, how can we install the 10 for order of the 10 for of the highway acts?
Yes, let us hear the state. Mr. Bandyopadhyay.
The pursuant to the Honorable High Court's order, my lord, there are several litigation as demanded, it appears from the order passed by the district magistrate, my lord. And my lord, all his application for long-term settlement has been, my lord, rejected twice.
The section 8 application has not
That
been
is after
considered.
that. That is
Because
after
they
that.
were rejected under
But
the
these
land reforms
proceedings has
manual.
been- That proceedings has been initiated pursuant to the honorable court's order, and my lord, the district magistrate also, my lord, hold that he is not eligible for the long-term settlement.
Under the land reforms manual.
My lord, what is happened, my lord?
Sir, my lord,
Please come to the impugned order. And the impugned order is not challenged.
My lord, 20, my lord, kindly see the 10 for order 24th of December, and his application under section.
my lord has been disposed of by the district.
My lord,
magistrate.
his
What was the
application
highlight?
for long-term settlement under section 8, that was, my lord, May 2023, long after the order of passed by the, my lord, the 10 for order was passed. 10 for orders, my lord, February 2023, and he made an application on 10 section 8, my lord, on May 2023, after the order was passed.
What, this is the 10 for order.
No, my lord, this is not the 10 for order. He has not annexed the order, my lord. This is the order of the 10 for. Well, he has not annexed the order,
This
my
is
lord.
Suppression of material facts.
Suppress, my lord, I have annexed this.
That has not been
My lord, kindly see. My lord,
stated in the
page
reports which are not
59.
annexed.
Order of
Where
the
is the
division.
order?
It has not been
Page
challenged.
59, order.
Not annex the order.
No,
Page 59, order of the division bench, 19th May 2023. Till this order, but everybody was at the impression that land belongs to the Jela Parishad.
No, it is not
Yes, my lord.
correct.
Yes, my lord. Kindly see the page 54 order of the district magistrate.
no.
They
How it is
rejected
done?
my claim only on the ground.
Is the order?
Notes of the section 215 and 219 of the West Bengal Land Reforms.
No,
Manual.
no.
Kindly see, my lord, page 54. This is of 17th February 2023.
He always stated he is an.
In the division bench, during the hearing, the state first time filed a report and said that the land belongs to the PWD. Thereafter, I made application under section 8 before the authority considered to consider my application. That application has not been considered. That is my affair. And secondly, my lord, how the private respondent is affected, how he is related with this proceeding, my lord. In any order, in any report, nowhere it is said that the private responses land egress and ingress is
Yes.
any way
If
affected.
this is the 10-4 order, what is this order then?
My lord, this is, my lord, with regard to the, they have, this district magistrate was directed to consider the representation. The order was, my lord, with regard to rejection of the representation. That is not 10 4 order, and that is not 17th of February, this order, and my lord, this order, appeal order on 23rd of February. The date is also different.
Section 8 application.
And 23rd of February, my lord, kindly see the order of operative part of my date.
Section 8 was never considered, my lord. Kindly see.
But
any
the
of the
section 8
order.
was, my lord, rejected, my lord, after filing of the rejection.
No,
Eight was
never.
No, my lord,
Never
the
considered.
application was not at the time when the application for section 10 for appeal was there. This is not in the picture also. He's there, when he's, my lord, everything is lost, he made an application under section 8. Not everyone, my lord, every encourager will be filing an application under section 8.
When section 10 proceeding was initiated, everybody was at the impression the land was of the Jela Parishad. Till the order of the division bench, my lord, nobody was aware that the land has been transferred to the
What
PWD.
was the order of the division bench
Yes, my lord,
passed?
that is at page 59. Kindly see, my lord. 19th of May 2023. Page 59. Page 59, my lord, kindly. No, sorry, 4th May 2023, page 55. Page 55. Page 55, my lord, relevant portion, my lord, is at page 57. Page 57, second paragraph, first 3 line. First time the government disclosed that the land has been transferred to PWD. Immediately thereafter, I made application under section 8. That has not been considered.
My lord,
This is the order of my lord, 4th May, and my application is 23rd May. 29th May.
19th May order directs the authority to consider.
Yes, madam.
Where is 4th May order?
It's 4th May. On page 55.
That is a single bench order.
Yes, single bench order. There the report filed and first time disclosed the land belongs to PWD. For that, everybody was at the impression.
No, everybody, except the petitioner, no one has the impression that PWD land. May I kindly come to page 37. The notice, proceeding was initiated Highway Act. Executive engineer has appeared. Before the executive engineer, before the executive magistrate, my learned friend client is appeared. Here I also said that this is the PWD land. Page 37, kindly see, notice was issued under section 10(2) of the West Bengal Highways Act. If the proceeding was initiated from the day beginning of the West Bengal Highway Act. He has fully knowledge he has fully knowledge the proceeding was ended.
The record. Present record of rights. Even today, that record of right is lying with them. Page 25.
They have applied for correction. That is neither here nor there.
So everybody was the impression that the land belongs to Jila Parishad. Even in the matter land, can you page 20, can you see the record of rights? Even today, that record of right is there.
That is neither
The
here
government
nor
record.
there, sir.
So, my lord,
Application
I'm
for
not-
encroaching
yes,
upon government land.
that may be wrong, my lord. But the document shows that apparent from the documents that the land belongs to the Jila Parishad. After filing the report by the government authority, first time we came to know that they belong to PWD. And immediately thereafter I made application. Understand? My only prayer is let them consider my section 8 application and dispose of in accordance.
Let them consider. I am not, but with regard to 10 foot order, he has suppressed that. He has not challenged the order. The order was 23rd of February.
10-4 order has been referred to in the division bench judgment.
No. My lord, yes, I have mentioned that. My lord, the order, because division bench filed by me. Division bench order, filed by me because in the writ petition, I was not made the party. My lord, only thing, my lord, the order of 10, even you know that the order was passed by 10-4. He has not challenged the order. But today, my lord, there is no stay in the 10-4, my lord. How can you stay, my lord, the 10-4 order? By initiating another proceeding. 23rd of February.
Then it was on the knowledge.
In the 26th July order also, this application has not been
It
considered.
was the knowledge of the petitioner, the land belongs to the PWD. As it appears from page
Yes,
37.
because section
Then
10
three
proceeding
notice has been initiated. Therefore, he is in the knowledge. Now he has come with the new plea that he does not know the knowledge of the petitioner, the land belongs to
And
the
my lord, most surprisingly, my lord, this order of 10-4, they have not annexed.
stated
Even
that.
in the earlier writ petition, not in the today, my lord, in the writ petition also. And kindly see the list of date also, my lord. In the
He has
list of date, my lord,
exhausted
they have
all
not.
his remedies, now he has come with the new plea.
10-4 was decided in February.
Yes,
So in February,
has
everyone
not
was
been checked.
aware that it is a PWD land.
yes,
You waited for 3 months and then you filed this application.
yes.
So
Yes,
no
my lord,
case,
I
sir.
filed this application only after the judgment of the
Clearly
Supreme Court.
suppression of material fact.
The second
Why?
time
After
order, my lord, kindly
10-4?
see
After 10-4, you did not know that this is
Yes, madam.
PWD land?
page 55, the order of the single page, when the order of the past, 4th May 2023.
No, nothing in this matter.
And 29th
And
May
he
I
has
made
also
an
suppressed the
application.
material, he has not stated anything.
Prior to that, you were not aware that this is PWD land?
Or perhaps not. Perhaps
Perhaps not 10-4, you did not participate?
yes, I participated.
So in 10-4, when is a proceeding under 10-4 initiated, sir?
All of that I-
It was your appeal under the Highways Act
Highway.
upon knowledge that it was highway land. So this is only dilatory tactics. That's all, nothing
But
else.
even then,
Thrice
even then
writ
the division
petition was
bench-
filed.
Not
well,
necessary.
division, even
Thrice
thereafter
writ
the-
petition was filed.
well, even, well, everything has been considered. by the
Thrice
division
writ
bench
petition
on
was filed.
19th of May.
From 2021 to
Everything has been
2023,
considered by the
that is
division bench on 19th of May.
Following the
Page
division
59,
bench's judgment,
that
the
has
order
been-
was passed.
Yes, yes.
Everything has been
And one-
considered.
Third
The
learned
division bench
counsels
directed
for
the
parties.
district
No,
magistrate
sir,
to
I'm
consider.
sorry. I'm
Well,
sorry.
kindly see.
No
Well,
case at all.
that every aspect has been considered by the division bench, and on 19th of May, the division bench passed on order directed the district magistrate to consider. Kindly see, Malad. From
Repeatedly he's
59,
done
from
an
59, Malad
And
onwards.
well, she's
But
admittedly is the
everything has
illegal
been
encroachment.
considered. Everything
And
has
he-
been considered, and even
He has
thereafter,
no right
passed
to
order
say.
directing the district magistrate to consider my claim.
He has no right to say.
From the day beginning, my lord, he has been, my lord, suppressed everything, my lord. In the
Yes,
writ petition, I was not paid party. I filed a division in matter.
Page
In the
62
initial
last
writ petition,
paragraph.
my lord, he has suppressed the order of the 10th
Page
amendment.
62, page
He
62
should have
last
come to the
paragraph.
clean end, my lord.
Malad, everything has been considered by the division bench and passed order,
And-
page 62,
kindly
this
see-
order was passed.
Kindly see the list of date, my lord.
When every proceeding was considered, Malata come to an end. Therefore, without going into the merits of the case, as all, at all, we only direct that that any hearing that the district magistrate may hold in terms of the order of the learned signature which is in order. The appellant, we have a right to participate. Sufficient notice of such hearing shall be given to the district magistrate to the.
No, I was not made party in the
So the
dispute, sir.
district magistrate shall consider the
And order was passed, my lord, behind my back.
in accordance with law.
Prior to the 26th July order, there was another order of the authority. Where is that order?
My lord, that is that, my lord, page 54, district magistrate's order. My lord, initially, this is the first order.
Can you see? District magistrate consider on the basis of long-term settlement of land reforms manual.
My lord, kindly
Section-
see, my lord, kindly see,
Section 8 was never considered.
kindly see, my lord, when the 10-1 proceeding appeal was going on, then he filed an application.
No, even after the appeal, the 10-4 was disposed of long back.
Long back. He
Well,
participated,
that
my
is
lord.
what division
He
bench have
accepted the
considered
order,
it.
my lord. He accepted the order, my lord. And he suppressed that.
And that order has not yet been challenged in the writ petition.
Heard learned counsels for the parties.
But may I leave the? I am not.
Even the division bench while passing the order, passed interim order in favor of the petitioner
Because, my
To
lord, at the
maintain-
time, my lord, he says that
to-
no appeal copy was served for us.
to maintain a status quo till the decision of the district
Uh,
magistrate.
All that is over, sir, long back. Now nothing can be done.
Well,
all
not
that is
long
over,
back,
long
the
back.
division bench passed order on 19th of May 2023.
But prior to that, 10-4 was already considered.
But I am not
already disposed
disputing
of.
this, I am not disputing, but
So
my
after 10-4, you cannot wait for 3 months.
only contention
You
is
are
only my
taking the plea of this court order.
My,
This is-
my
this is
only
not
contention
this
is
case.
in terms of the division based order, my prayer has not been considered. Section 8 has not been considered. That is my only prayer, nothing else. But I am
Order doesn't say section 8.
Deeply ordered.
It says section
representations, my representation is to consider.
1 and 15, the reconsideration. It
Madam.
never says section 8.
Because at that time, when the division bench order
No section 8.
District
District
magistrate
magistrates have considered the representation of the petitioner in
at the
accordance
time
with the law.
It's the earlier representation, sir,
Yes.
not the new one.
At that time, there is no
Because
section
this
8.
representation was not there at all at that time.
Thereafter, the DM himself forwarded my
No.
prayer to the executive engineer.
Not
This
forwarded.
is the order, page 73.
Not forwarded.
This is the order of the DM.
No, no.
Can say DM ask the because under the section 8 act, executive engineer is the authority to consider. That is why DM forwarded it to the executive engineer.
Forwarded, my kindly see
Can
the
you see?
order.
Can you see the last one paragraph? Page 73. My only prayer is let him consider before passing that order. Division bench forwarded to the district magistrate forwarded it to the executive engineer, who is the authority in terms of the section 8.
This is the representation dated October 11, 2022.
Executive engineer public was no, my lord. Consider that representation was rejected. The executive engineer public was directed may take necessary action on the basis of the application of the writ petitioner as per law.
Application, it is very vague.
That's a 29th May.
How do you know?
How-
Where is it
Page
stated?
64?
29th May? Where is it stated?
But
29th
say-
May
that is my
application?
only application under section 8.
No, no.
This is my only
Refer to
application.
at all here.
But
There is
date
no
has not been
reference
referred,
at
but
all.
that is why it has been referred to the executive engineer under the section 8. Kindly see that section 8, who is the authority? Malad, can you see?
The case has a checkered history.
That is why application was,
Sorry, sir.
Team has been
Can't be
to-
considered.
Malad, page 72, Malad.
Please, you're repeating your submission, sir. It will not help.
Malad, can you see,
Only-
Malad,
only count
page
the
72,
suppressor.
Malad, page 72, second paragraph. That application has been referred, Malad.
The team has.
Malad, page 72, Malad, second paragraph. His
Yes,
client
as per direction, this is the,
land in question under the Anasala Highway Act. So my application under the Highway Act was
No.
not considered. That has been clearly stated in the order, my lord, in the district magistrate.
Very well, let the application be considered within 2 weeks.
Yes, my lord, that is my prayer.
My lord, in the meantime,
Let it
my
be
lord,
considered.
order, my lord, kindly keep in effect, my lord, because 10 for order was 20 order. My lord, they not challenge the order, they suppress the order. My lord, let them consider, let them not take release with regard to that. Let them grant release. But my
2
lord,
weeks, 2 weeks.
my lord, with regard to my lord, that, my lord,
The case has a checkered history. Paragraph 4.
my lord, this is the only attempt to drag the
It is
position,
not in
nothing else.
dispute. I'm dictating out this, sir.
And my lord, you also kindly
You have
confirm.
waited for such long, wait for 2 more weeks. And then after that, it will be executed immediately thereafter. It is not in dispute that the petitioner is in possession. The petitioner has been occupying
96 square
a
feet of land.
portion of 96 square feet of PWD land in LR plot number 2603/3276 in Mouja, Visheshwarpur, jail number 163, and runs a shop therein for about 31 years. Stop. The petitioner initially filed an application before the concerned authority for grant of long-term settlement terms of sections 219, 220,
Yes, my lord.
219 and 220 of the West Bengal
Land reform.
Land Reforms Manual 1991. Under one, since the petitioner was under the impression that the land belonged to the Jela Porishad. Stop. Subsequently, it was learned that the land was transferred to the PWD by the Jela Porishad. Stop. Proceeding under Section 10 of the West Bengal Highways Act was initiated against the petitioner and taken to its logical conclusion by an order under Section 10(3) of the Act. Stop. The petitioner preferred an appeal against the said order under Section 10(4) of the Act, which was considered and dismissed by the District Magistrate South 24 Parganas by an order passed on 24th February 2023. The petitioner's prayer for long-term settlement of the plot was turned down by the authority, against which the petitioner filed a writ petition before this court.
Yes, 55.
Why was the single judge's order carried in appeal? What?
because single judge was initially
He
directed,
preferred appeal.
I'm asking. the
But he
petitioner.
preferred appeal, my lord.
Yes.
He preferred appeal.
because I was not fit
Not
party in the writ petition.
Where is the single judge's order?
Yes, 55, my lord.
Stop.
Only thing only-
By an order passed on 4th May 2023 in WPA 7184 of 2023, comma, a coordinate bench of this court set aside the said order and directed the concerned authority to pass a fresh order after hearing the parties and taking into consideration Rule 238 of the manual within a stipulated time frame. The order was carried in appeal by the private respondent herein. Yes. And an honorable division bench of this court, comma, by an order passed on 19th May 2023 in MAT 828 of 2023, comma, reiterated the order of the learned single judge. Stop.
Page 63 at the top, the direction upon the district magistrate. Page 63 at the top.
Accordingly, the
Your lordship kindly come to my lord, section 8 of the one before your lordship,
of the petitioner was
section 8, my lord.
revisited by the authority and turned down by an order passed on 26th July 2023. Stop. After the order of the Honorable Single Bench, the petitioner filed an application before the executive engineer, comma, Diamond Harbour Highway Division, comma, PW within bracket roads, bracket close, department on 29th May 2023 under section 8 of the West Bengal Highways Act 1964, seeking regularization of his possession in respect of the plot in question. Stop. Paragraph. Learned counsel for the petitioner submits that the said application is yet to be considered. Learned counsel seeks a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that the earlier representation submitted by the petitioner was reconsidered by the authority in compliance with the order of this court, and the petitioner was all throughout aware that the land in question belongs to the PWD, since proceeding under section 10 of the Act of 1964 was initiated and concluded, and the petitioner also preferred an appeal against the order passed under section 10(3) of the Act. That is your case.
No, I had one thing, no, my lord, section 8 does not, my lord, speak out about regularization. Your lordship kindly see the Highways Act, my lord, section 8 of the Highways Act does not. Section 8 said, if a person is going to, my lord, occupy the land, he made a public. Kindly come to, my lord, 2, my lord, kindly come to 2. My lord, no person, my lord, section 8 of the original Highway Act.
Give me a minute. Please.
Regularization, with regard to section 8, my lord. First, my lord, no person shall make any. And the second, my lord. There is no such permission, my lord. The person is ongoing in possession, my lord, for granting, my lord.
That the authority will decide. The court will not decide on merits. Generally, what happens is under section 8, a regularization of the already occupied portion.
Yes.
Straight.
My lord, your lordship,
So let the authority consider in 2
your lordship
weeks.
kindly visualize all situation, my lord. Since 2021, or one after another. My lord, today, my lord, executive engineer pass an order. Again, they are challenged, or it will be continuing. There never been any end. My lord, he was declared as
The law
my lord,
permits the
my lord,
petitioner,
I am
can
not,
you stop?
my lord, I am not standing in the way. My lord, let them consider and let them, my lord, allow to grant. My lord, with regard to that question, or with regard to, my lord, 10-4, which is they are not challenged. They are
I'm not touching upon 10-4. 10-4 is not the subject matter of the petition at all.
But the notice was, my lord, in consequence of the 10-4. That is, the notice for removal in consequence of the 10-4 notice. 10-4. My lord, the 10-4 was rejected the appeal and recovered the possession. Let the recovered possession was granted if they granted, my lord.
Will decide, and if it is decided in the negative, immediately steps will be taken
Yes, my lord.
for removal.
Yes, my lord.
But my lord,
2 weeks, you have to wait for 2 more weeks for no coercive action to be taken.
my lord, only thing, my lord, what they have not done by challenging the my lord, 10-4, my lord, they have done, my lord, in some other way. My lord, you will also kindly see their conduct once. My lord, initially their application.
Do you mean to say that the law doesn't permit the petitioner?
No, my lord, that is, I am not, my lord.
If the law permits, please do not make so
My
much
lord,
of submission.
how many
on
times,
it.
my lord, they consider, initially district magistrate consider rejected?
Is it barred by law? One answer, yes or no?
No, my lord, I have not said once time, my lord.
It is not barred by law. How can you stop the petitioner from doing it?
No, I am not, I am not praying. I am humbly praying to your lordship not to stay the order of the appeal, 10-4 appeal, because they suppress that. And
10-4 will not be stayed specifically. For 2 weeks, no coercive action will be taken. Yes. Paragraph. It is a fact that the petitioner was aware of the fact that the petitioner was aware that that the plot in question belongs to the PWD from the date of initiation of proceedings under section 10 of the Act of 1964, comma, if not earlier. Stop. Be that as it may, comma, since the petitioner has made an application under section 8 of the Act of 1964, which is pending, comma, the concerned authority, comma, being the assistant engineer should consider, isn't it?
Executive engineer.
Sixth respondent? The sixth
Yes.
respondent
Hmm.
is directed to consider the application dated 29 May 2023 within 2023 and pass a reasoned order within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondent, comma, in accordance with law. Paragraph, pending disposal of the application, comma, no coercive steps be taken against the petitioner by the authority in respect of the plot in question. Paragraph, if the application filed by the petitioner is decided in the negative, comma, necessary steps be taken by the authority under section 10 of the Act of 1964 forthwith. Disposed of which?
Deeply obliged.
Now, 2 weeks from the date, madam. 2 weeks from date. 2 weeks from the date. Today,
2
madam.
weeks from the date of communication. Communicate the order. Because the authority is there here in court. Act line করে দিন এখন শুরুতে। The matter has been inadvertently listed as WPA 23844 of 2022 instead of WPA 23844 of 2023. Inadvertently বললাম তো? Paragraph, by consent of the parties, WPA 23844 of 2023 is treated as on days list and taken up for consideration. Cover heard learned counsels for the parties. Next. Item 2.
Item 2, I beg to appeal for the petitioner. In this matter, on 11th of August, an interim order was passed. This is regarding, my lord, acquisition under the Metro Railways Act. Now, my lord, your lordship, my lord, has already given a judgment in a similar matter where, my lord, the 2013 Act applies to acquisition under the Metro Railway. Here, my lord, the complaint authority passed an award, my lord, giving, my lord, 2,60,000 as, my lord, compensation amount. We preferred an appeal. They also preferred an appeal. It was enhanced to 3,06,000 per decimal. Now, my lord, we have challenged because no interest has been given. Although, my lord, they have taken possession, they have installed the board. Now, on the first day, my lord, they were directed to submit a report on the matter, and, my lord, interim order was passed that they shall not disturb, my lord, they will not make any construction over the property. Status quo to be maintained. This is the position.
This is the report, my lord. I am slightly, my lord, out of time, my lord. Can you pardon me, my lord?
Have you served
I
the
have not.
copy?
Yes.
No, copy.
And my lord, so far as payment is concerned, my lord, on 29th of,
Day 6 for extension of interim.
yes,
order.
yes, it can be extended, my lord.
Let there be a date, it will be extended for a limited period.
What I am saying, my lord, on 28th of September 2023, my lord, we have deposited the entire amount. That is, my lord, 66 lakhs, 5,520. So, my lord, I don't know, my lord, whether Mr. Banerjee will eager to keep this liquidation pending.
Yes, because we have not challenged on the ground of interest. We are entitled to interest under section 80 of the 2013 Act. No interest has been awarded.
My lord, then in
And-
that case, my lord, kindly, my lord, so far as interim order is concerned, my lord, kindly record my statement that we have already deposited, my lord, 66 lakhs, 5,000, my lord, 520 on, my lord, 28th of September 2023.
I'll
So,
record. I'll record. Let
So-
there be a limited extension.
yes, well, interim order is there, my lord, we cannot make any construction, my lord, that's why I am saying so.
Report in the
But,
form of affidavit submitted on behalf of respondent numbers 1 and 2 is taken on record. Paragraph, learned counsel for the petitioner seeks extension of the interim order granted earlier. Paragraph, learned counsel for the respondents / Metro Railways submits that the entire amount of rupees
Of rupees 66 lakhs, 5,520.
has been deposited by the authority on
On 28th of September 2023, 28, 28.
8th of September 2023. Stop. Paragraph, since the interim order granted earlier has expired on 30th September 2023, comma, the said order be extended till 30th November 2023 or until further orders, comma, whichever is earlier. It's at the motion stage.
Motion stage, my lord.
Paragraph, let the matter appear under the heading Group 1 motion on 23rd November.
Third November. So we shall use an exception to the report if necessary, my lord.
যেখানে report বললাম ওখানে on prayer of the petitioner, liberty is granted to use an exception to the report if, comma, if required.
Develop.
But the amount deposited may be released in the meantime because as per the statute, once it is
Consider and come.
fine. Much obliged. my lord.
Item 3.
Yes, my lord, I'm for the petitioner one app.
Respondents,
My lord, he is appearing for KMD and my lord, Mr. Chondichanan appears for this state. Now, my lord, what happened, my lord, on 4th September 2023, that appear under reading for hearing.
oh, this is a dismissal. You are asking for restoration.
On a finger.
Restoration.
Restoration. And secondly, my lord, an application for substitution, that application may be.
Where is that
The
application?
order,
Application
order
of
he
one-
seeks. You should kindly have a look the order.
I mean, this is my lord, bona fide mistake. Your lordship, you are accusing your lordship's order. My lord, the order, my lord, bona fidely one mistake on 4th May 2023. It should be 4th.
It has gone down as
My
4th
lord,
May,
No, no, no.
4th May instead of
The date of the order.
date of order.
It's 4th May 2023.
But order says 4th May, but dismissal was on 4th September.
No, dismissal was 4th May 2023.
No, my dismissal on 4th September.
Where is that order sheet?
my lord, order, my lord. It is my lord mistake I
Fourth
mentioned.
May, it was dismissed. After that, there is no order sheet.
No, no, my lord, my lord, on,
2, 3,
instead
4,
of 4th May, my lord, it should be 4th September. So, my lord, ACOs, my lord, typical. That was not the one lord, issue. And the server copy, my lord, I obtained, my lord, on the next day, my lord, on the same day.
But the dismissal order, the order sheet says 4th May.
And yes.
From where where is the 4th September order? Please show me.
4th September, my lord, your lordship, my lord, see the one lord, the combined monthly list on 4th September matter appear, my lord, under heading for hearing. And my lord, on that day, the matter was called on and it was taken up by your lordship. Since nobody appears, man, your lordship, the matter was dismissed. for
Monthly
the
list of September to the.
my lord, it is true. My lord, my learned friend is present. My Mr. Satyajit Talukdar present on 4th May. He cannot deny.
4, 5 holo correction.
I'm not denying.
Order
My lord,
sheet
he is
4,
denying.
dismiss for default.
My lord, it is a my lord, sticky mistake, my lord. My lord, he was present. He had been present on that day. How he was saying that the court has called? My lord, it may be happened, my lord.
September to May করে দিয়েছেন।
Your lordship kindly recall that order and my lord, and also application for substitution be disposed of.
After see the original, my lord, that is your lordship's order is there, that is.
This is the original order.
Yes, my lord, so
Five.
my lord, he must file an application on that day. He is bound to do so.
September. No, the dates are September. There is a mistake in the order.
Order.
কি গো বাবা তুমিও সিনিয়র তুমিও হচ্ছে
Application has not been- পুরো দিন inadvertent-
জজের ভুল হতে পারে না তোমার ভুল হতে হয় না
যদি ভুল হলেও আমরা ক্লারিফাই
আপনি
করতে
দেখে নিয়েছেন
my lord clarify করতে।
আগে এটা কারেকশন করুন হ্যাঁ WPA এটা করে দিন inadvertent error has created the order passed
চার নয়
in the said order 4th May 2023 be read as
200 yes
2023
মানে item number
But-
200 also
Sort
mentioned
order
in
the-
my application
treated as part of
900
but can 2 of 2023 restoration within
And-
time yes
and can one is for substitution that application may be allowed. Mother, I think my learned friend should not oppose.
substitution where is your application
Application can one of 2023. Mother, the 2% died by
you have a copy can one
yes, can one. It was mother, this is epitome of service.
Let it be first restored.
it is restored already
Mother, can it was served, can one.
এই কপি নেই অরিজিনাল নেই
can one is not in the file I think
Yes, can one is my lord is in the original file.
Achha.
Can one is there, my lord. Because this
can 1 of 2023 is listed not 2022 এটা can 2 of 2023
can one হচ্ছে দেখুন
23 না 22.
দাঁড়াও এক of 2003
can one listed file নেই
can one
can 223 is just
can 2 is the restoration
Yeah.
application can 1 is not in the file
can one is not
but matter is
you
appear.
have copies of can 1
Yes,
Right
I
now,
have served.
cannot say well, might have served.
তাহলে আমি এটা ডেট রেখে দিচ্ছি একটা let there be a date of the
Yes,
WPA I'll fix a date
Let us also check.
along
My lord, on that day of hearing, my lord, the application also
in
appeared.
the file let there be another date computer WPA তে order করুন let the matter appear under the heading group it's a
I mean,
group,
it's a
group
long-
one motion
My lord,
group one motion
yes,
It's a ready matter.
hearing matter affidavits are complete
ready, evidence is complete.
and hearing
My lord, it is a land acquisition in the year 1979. Land was, our land was acquired. Till
11th
date, no single
11th
party.
December 11th December
11 December.
তার আগে একটা লাইন
My lord, top, your lordship,
WPA
kindly
the
give
can 1
priority.
of 2023 is not in the file the department is directed to put up the application along with the file on the adjourned date
My lord, let the appeal be, my lord, placed at the top, my lord, because my lord,
come back
all
Because
the petitioners, my
2017
lord,
matters generally come
their
at the
dates
top.
are alarming, my lord. They are,
2017 matters generally come at the top. Come back, let me see. It's an old matter.
so, my lord, your lordship desire to take the
Substitution.
11 December.
your lord, 11
Hमें
September,
department के direction दी थी।
11 December, your lordship desire.
Next.
My lord, affidavit service, my lord, file we kept with the record.
Rajiv, affidavit of service. Item 4.
My lord, item number 4, I beg to appear on behalf of the petitioner, my lord. Copy
Appearing
is
for the first time.
No, my lord. It appeared before, my lord. My lord,
Have you served?
my lord, it has been served, but the affidavit of service is not ready. My lord, kindly a day's accommodation may be granted for.
After vacation. Since service is not complete, comma, let the matter stand over till 24th November.
My lord.
Next. Item 5.
Lord, I am appearing on behalf of the petitioner, my lord. Your lordship's order has already been complied with.
Has been complied with. It is submitted on behalf of the applicant petitioner that the order under contempt has been complied with. Paragraph in view of the above, comma, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no arrest to costs, urgent certified, etc. Item 6.
I am for the applicant pursuant to your lordship direction,
this-
copy has been served to the alleged contender.
Well, in this regard, my lord, I am appearing for the writ petitioner. Well, the concerned district magistrate pursuant to lawsuit directions on 8th February 2023.
You are appearing for the writ petitioner.
The writ
He is
petitioner.
a
Well,
encocher, that's
no,
why
no.
he is appearing on the last occasion, lordship
Well, there is a
already
dis-
observed.
Well, there is a dispute in enclosure. Your lordship will elaborate a judgment passed by on.
You are the
8th
applicant.
February.
Yes, I am affecting party, lord.
Well, kindly see the notice.
My
27th September
pursuant to your lordship direction,
2023.
lordship served the copy of the.
Well, the hearing was took place on 11th October. But this is the notice. Pursuant to lordship directions.
After serving the copy, lordship
Who is
says
appearing for the alleged contemner?
district magistrate is the alleged contender, respondent number 2. Lordship, kindly come into the page 25 of the contempt application, lordship.
The 8th February. Last order.
8 February order was passed, till
Yes,
date
not
they are
based
not
on-
deciding the issue.
The respondent number 2 is further directed to conclude the hearing within 4 weeks from the
Please
date.
wait, sir. You are no one in this matter actually.
Yes.
Let the applicant speak.
আমাকে এটা
এটা নিন।
আমার মনে থাকে।
District magistrate is served.
Yes, lordship. And I already delivered those.
What is his name?
Lordship,
You have not
Prinendu
served.
Maji is the
You have
district.
not served by name.
Lordship, by name has been served.
No, this doesn't show that.
নতুমাজি নেই।
You have served the district but the
But
office.
recently, lordship, DM has been changed.
So you have to serve the person, you have to add the present DM in that case. And you have to serve by name. Contempt application cannot be served in the office.
On earlier income.
He is the earlier incumbent. But item has been delivered.
ওদেরকে order এটা। Orderটা করে দেন।
8 February.
না 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 কন্টেম্পট এই অ্যাপ্লিকেশন কন্টেম্পট এর আগে ছিল 20 সেপ্টেম্বর কি দুবার নিয়ে কেন
After serving the copy, lordship contempt
In the
application,
contempt application, you have not even named the alleged contemner separately. Where have you named? the
name has
alleged
been
contemner?
given, lordship.
In the cause title, please come to the cause title.
Yes.
Where have you named the alleged contemner?
Respondent,
That page?
অনেক বড় কনসিডার করবো,
অনেক বড়
একটু বড় কনসিডার।
Lordship, kindly come into the page 15, Lordship.
Purnendu Maji.
Purnendu Maji is the alleged content.
So you have to serve Purnendu Maji,
Kindly give them,
not the office.
kindly give them direction, Lordship, fresh.
No direction is necessary, sir. You have not served. Take this back. You've served the office.
His office already been served, Lordship.
Office, that is, you cannot serve the office in a contempt application. Contempt is a personal responsibility, isn't it? Yes. Since service upon the alleged contemptor is not complete, comma, let the matter stand over till 30th November.
13 number.
Rejected, my lord.
There are two supplementary affidavits.
Yeah, I have some.
There
This
are
is
two,
rejected.
Yes, yes, two supplementary affidavit.
Two supplement. I am
The
coming back.
impugn order which they have annexed is
5th
the
of January.
affidavit
It's affidavit
5th
dated
January,
5th
if I'm not
January.
5th January.
yes. Yes.
And kindly come to page 12 of the fragment affidavit. Your lordship's clear direction was you have to consider the letter dated 11th of January, June 2011. What the authority said, the issue, the letter of the BLLRO, Santuri dated 11th of June 2018 is an internal administrative communication between hierarchy, but internal communication cannot be treated as an order. The Honorable Supreme Court of India, in the matter of Union of India and other verses, Katitanda Mundal and other civil appeals such and such, observe that the next issue is that we are required to consider pertains to internal communication which are relied upon by the respondent and which are also referred to by the tribunal as well as the High Court. Especially the aforesaid communications were exchanged between the officials at the level of board hierarchy only. An order will be deemed to be a government order as and when it is issued and published. Internal communications while processing a matter cannot be said to be orders issued by the competent authority unless they are issued in accordance with law.
That is settled law. Yes.
But for that reason, they did not consider. For that reason, they did not consider your lordship's order. But I have brought Evidence Act. Section 74 says it's a public document. Public document, you cannot say that there is an internal communication. Kindly see.
No, even if it is an internal communication, when the court has directed to consider, they have to.
They have not considered. They have not considered. My prayer is let them reconsider. The order passed by the AGM is liable to, on that ground is liable to set aside.
Let us hear the authorities.
And your lordship kindly second supplement affidavit. Your lordship kindly see. Kindly come to page 4, my
report.
11th of June, the order BLO said at the ADMLR, SDLO, my lord, address to the ADMLR. The places by the bank river Damodar under PS Santuri, which have been identified by tribal villages, Alkusha, accompanied by the lessees for the traditional use of funeral purpose by the tribals in the locality, have been proposed by the tribals to be restricted for sand mining. Clearly observation is there. They cannot do it. And your lordship kindly come to paragraph 3.
No,
Paragraph 3 more important matter. In respect to few floors, the official is the second paragraph, second line.
officials of Santuni police station is also apprehending of local resistance to come from the Bardhaman side, Paschim Bardhaman side. If we go to the court within the route of Paschim Bardhaman district under Hirapur police station jurisdiction to take any action for removal of them, which may lead to a serious law and order problem in the area. Therefore, my lord, funeral place of the tribal people is confirmed. I could not oppose my lease. Lease has been granted in my favor. I could not operate, I could not minor. For that reason, I prayed for reallocation of the plot of land, my lord, so that I have deposited money, not fully, but initially I deposited 1/3. But because of the resistance caused by the tribal people, I could not operate. Let them reconsider, my lord.
বলবেন আগে আপনার তো অর্ডার আপনি বলুন তারপর আমি বলছি
The order dated 10th of November 2022, it was communicated by the AGML much after the order passed by him.
Let us hear the authority.
Lordship, in this connection, there are several writ petitions already filed. And also the contempt application already filed, and that contempt application already disposed of.
Writ petition, earlier writ petition.
Lordship,
Which writ petition is that? On the same issue?
same issue.
On that
There is
issue,
a-
your lordship directed them to cancel the order because the 11th June order was not considered and written representation, which
That
was,
part is over.
yes, my matter is disposed of. Contempt matter file disposed of.
Again, that instant writ petition already filed, my lord. So at this stage, according to the period, the supplementary affidavit, but there is no any mention to set aside that order in the writ petition.
Which order?
Supplementary order, my lord, kindly second.
the order of the ADM, which is
Order of the ADM.
10th of November
under
2020.
challenge.
Page 8 of the first.
The either consider the representation or the necessary reaction is necessary.
No, order of the order.
Have you amended the prayer?
No, my lord, your lordship
No.
directed me to file supplementary affidavit challenging that order.
Where
that
have you
is
challenged the order?
So see, the
But what is-
supplementary affidavit, the order has been annexed and the impugned order which has been annexed with the supplementary affidavit, Lordship, that is an appealable order in terms of Rule 51. And the Honorable Division Bench,
Because
in identical matter that has been upheld by the Division Bench, sir, unreported judgment, MAT 1186 of 2023.
only more has been
You're
prescribed.
challenging the order passed by your lordship because your lordship directed the writ petitioner to approach the
Appellate court.
office of the divisional commissioner. Challenging that order, the writ petitioner preferred appeal before the division bench. And the honorable division bench set aside, dismissed the appeal, upholding the order passed by your lordship and granted liberty to the appellant to approach the divisional commissioner. Because there is alternative efficacious remedy, lordship.
Your lordship's order was specific. You consider the matter in prescribed mode.
Yes.
Your
but
lordship had
you
prescribed
are
the mode.
challenging it on merits. Merits of the order. They
But
have-
that was not considered. I am praying.
So they have considered and they have said it cannot be taken into.
But that was not considered in terms of your lordship's prescribed mode.
I'm sorry, Mr. Shamanto.
Mala, kindly come to my lord. I could not convince your lordship, my lord. Kindly come to your lordship's order.
I have seen the order.
The order dated 24th of August is bereaved of any observations because in view of the court is inclined to hold impugned order is required to be set aside. Concerned authority directed to reconsider the prayer of petitioner upon taking into consideration the letter dated 11th of June 2018 as well as the written argument submitted by the petition before the authority. But they have not considered that 11th of June order.
They have considered the 11th June order and said that since it is not an order, it need not be taken into account.
Yes, ma'am.
So they have considered and refused.
They not consider.
So
They are
this is
not
an
total
appealable order,
considered.
Mr. Shamanto.
Let them file appeal.
This is an appealable order. No affidavit required.
This is section 74 of the Evidence Act. People obviously kindly see.
That is on merits.
Still there, my lord, they cannot take advantage of your lordship's order in that way. They could not do it within time. They did it, they communicated after long lapse of time. Your lordship pardoned them and directed them to communicate the order. They communicated. Thereafter, my lord, your lordship's order, I have submitted my supplement affidavit in terms of leave granted by your lordship. Now they cannot say that it is a appealable order, go before the appellate authority. They cannot say.
I
It
can
is the fit
at
case
best-
for reconsideration.
I can at best consider the limitation period because that is over, I think.
That you can do.
I can at best consider that
That-
period.
Then
The heard learned counsels for the parties. The writ petition was initially filed
original prayer
with a prayer directing the respondent authorities
mining
to
lease.
grant mining lease in favor of the petitioner
And the auto loan
by allotting an alternative area for mining, since the petitioner was unable to commence mining operation in the plots allotted to him. Stop. The petitioner has subsequently filed a supplementary affidavit annexing an order passed by the additional district magistrate and district land and land reforms officer, Purulia, passed on October 2022, on 14th October 2022, in compliance with
they have
an earlier order
they passed
passed
the
by
10th
this
of
court.
November. 10th of November, they passed the order. 10th of November.
They passed the order on
14th of October. 14th of October. Yeah, lost right. 14th of October. A communicated letter.
in compliance with an earlier order passed by this court on 15th September 2022 in WPA 20503 of 2022. Paragraph. The petitioner paragraph number একই সাথে করুন. The petitioner assails the said order. Stop. Paragraph. The order impugned is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules 2016. Stop. In view of the above, the writ petition is dismissed, being not maintainable. Paragraph, however, liberty is granted to the petitioner to approach the appellate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers statutory appeal within 7 days,
No,
2 weeks,
within 3 weeks, my lord. Within
4 weeks,
within 2.
because vacation
4
is
weeks
approaching.
limitation. Very well, the
Within-
vacation is intervening.
Within 4 weeks from date, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of limitation. Paragraph, there shall however be no arrest to costs as in certified website. Khali duty line.
Yes, that's okay. Lordship, may I cut the order? Get.
Item 8.
No, for the response number 7.
Service malad substituted service by application malad. Direction of the lordship malad.
Substituted service on private respondent.
Private. Because it was tried malad to 5 addresses, but all are returned. Very peculiar issue has been arisen for kind consideration of your lordship.
By the name.
Very innocuous prayer, my lord, in the repetition.
Who are the other respondents?
My lord, Calcutta Improvement Trust, that is the Calcutta Metropolitan Development Authority came here.
There is a can, but there is a can, an application.
For substitution service.
Oh, this was the application.
Substitution service.
Kolkata
Kolkata Municipal Corporation. My lord, the Kolkata Metropolitan Development.
Who is appearing for the state?
Yes, yes.
I'm for this state, response number 7, Polish.
Yes. Yes.
My lord, kindly have a look to the prayer, my lord, the case 26 of my repetition. Very innocuous prayer, my lord.
26
Reading the nature of mandamus commanding the respondent authorities, particularly respondent number 2 and 6, to identify and demarcate the inherited property of the petitioner on the basis of the master plan or survey map lying with the officials of the respondent authorities and in presence of the petitioner or his representative and in the presence of the private respondent and a representative, and also by applying other necessary modes or procedures effective thereto, and also identified.
How can private properties be demarcated by government officials?
No, my lord, here the issue is not like that. It is not the same property claimed by both the parties. There is no rival claim on the same property. That is the whole
It's a
difficult.
private dispute.
No, my lord, kindly appreciate. If I, my lord, file any civil suit, sir, I have to file on my property. That is the different number, separate number. My lord, private respondent, my lord, claiming a separate premises. My lord, if I file any order suit, and my lord, I cannot apply order 26 rule 9 for eliciting, my lord, and my lord, in this case, my lord, plan has been sanctioned and KIT, my lord, issued one site plan.
Can the authority demarcate private property? This is a private dispute.
My lord,
Absolutely.
my lord, kindly have a look. Already they have, my lord, to identify.
I do not know what they have. Please tell me the provision of law.
My lord, kindly have a look, my lord, page 93, my lord. This is, my lord.
Simple question. Can the authority demarcate private
Well,
property?
here the issue is, my lord.
Is there any provision, whatever the issue is?
My lord, here the, my lord, issue is, my lord, that the KIT has, my lord, one master plan, wherein, my lord, the entire premises, my lord, has been
Is the
sold.
KIT bound to provide you with that master plan for your own?
But that's
purpose?
why we are approaching your lordship, my lord, because, my lord, kindly,
I want to see the provision.
my lord, kindly appreciate this, my lord, that if I, my lord, if my lord, your lordship, my lord, says that I have to file one civil suit, my lord, what
I
really?
not say anything else. I only would like to see the provision under which the government officials.
They have
can
the
be
authority because,
survey your personal.
because, my lord, the KMC has given the number of the premises number.
Maybe.
But it has,
So approach the KMC.
my lord, KMC is a party. KMC is a party.
The writ court cannot help you, sir. I'm sorry, you have to approach the KMC.
My lord, KMC is the party. My
Can
lord,
you approach the KMC?
my lord, my lord,
Made them a party.
well, in that event, my lord, the coordinate bench of the court, my lord, passed an order directing KMC to identify the property, my property, because they are.
Show me the order.
That is, my lord, not lying. That present lying of my case. I have argued.
Private dispute. Let us hear the respondents. Yes.
No, my lord, kindly,
I think I have spoken
just
to the
bear,
respondents.
well, just bear a moment, my lord. For my satisfaction.
KMC is also here.
My lord,
Correct.
the premises number has been allotted by the, my lord, the KMC.
Maybe.
The name of the road has been given by the KMC.
Maybe.
But if someone says,
I don't know how the demarcation can be
but
done
if
by
someone says, this is not the property,
right,
this
your
is
lordship
not
has
that
right
property,
here.
is that property? Number one.
Unnecessary wastage
If
of
for
time.
declaration evidence is necessary, the court will do the
But
needful.
I cannot apply to order 26 rule 9 because it is, that is one of, for
You
existing
can apply for
evidence.
declaration also of your property.
What, well, I put this question to myself, Mala, what declaration that I am the owner? Well, it is,
I
not-
will not go into merits of any.
my
civil
lord, kindly appreciate.
What
Well,
is the primordial prayer?
Provision in support of your.
Well, in that event, my lord, I will show that the order of the, my lord, to coordinate bench, that direction has been given upon the corporation to identify a property because they are realizing tax.
I have to see the facts of the case also.
Same problem.
That
If-
is to see.
Same problem for identification.
If my learned friend has finished, your lordship, kindly have a look, paragraph 21. What for this writ petition is, my lord will find.
No, no, that is my property. My lord, can you appreciate? I can, my
Allow,
lord,
allow me to make.
no, my lord, if that
Submission.
is, that is a
You
submission.
finished the submission, let
Yeah.
Mr. Taluga submit.
Allow us to say something also. Your petitioner states that while the appointed developer of the petitioner and his associates tries to commence the construction work with regard to the proposed development project, all of a sudden, concerned police officer of Kosba Police Station intimated the men and agents of the developer with an order of the application filed under section 144(2) of CRPC, MP number so and so, wherein that the learned executive magistrate second court at Alipur by order dated 14 restrained the petitioner and his associates from doing any illegal acts. Now,
144 between private.
now,
individuals.
Lordship, kindly come to the prayers. Prayer A, my lord has seen
But that is with regard to another property. Totally another property.
whether any
Another property.
any such writ of mandamus can be issued.
Cannot be, cannot.
Cannot, in that event, my lord, kindly give a chance to file the supplement, my lord, because coordinate bench, my lord, directed the KMC to, my lord, identify a property.
Come back with the other.
Not,
with the
not my
documents.
lord, not
Each
my lord.
case to be
to
decided
trace out
on its
the
own
title.
facts.
No, no, my lord, I am not, my lord, submitting people to trace out the title. That is for identification.
I understand, but how can the writ court do it? Please show me the provision.
But that in that, I will.
It,
Prima facie hold that the writ court cannot do it. Your application is
The
not.
primordial
Lord,
prayer.
it-
If you want to come back with the judgment or whatever you say, you can come back.
My lord, that is the order, that is.
Since I have a good mind to dismiss it, I'll give you the liberty. Come back.
my lord, it goes against the basic principle of law. My lord, what one cannot
No, my-
achieve directly, he cannot.
Let him come back. Let us see some what judgment he has to show.
I do not know what you.
Yes, my management knows,
View that
because
it's-
in that,
I do
in
not-
that matter,
Primordial prayer is once the demarcation by way of this KMD. You cannot do it without this.
The petitioner seeks demarcation of his
নয়টা দিয়ে ওখানে কত হচ্ছে আবার আমার ওখানে
private land.
আর ওটা 9টা কোথায় ঘোষণা কোথায় গেল
ওই ম্যাটারটা ওই ম্যাটার না না এটা কর্পোরেশন থেকে হলো এটা কেএমডি ছিল এখানে
The petitioner
সিদ্ধিধন
also seeks an accommodation.
সিদ্ধিধন আরে ভাস্কর
Let
চ্যাটার্জি
the matter appear under the same heading on 28th November, 28.
28.
November.
supplementary affidavit by way of supplementary affidavit I have to place that order.
Drafting it. Also says for the- On prayer of the petitioner, liberty is granted. A supplementary affidavit and please serve it as.
Whether he can improve his case, basically.
That is order I have obtained. I argued.
Let him try.
I obtained. My learned friend knows he was in another matter.
I know that that is that cannot help you.
Item 9.
I'm for the respondent.
Lordship, I am for the petitioner. Lordship, may I proceed? Lordship, one lease agreement was entered into your lordship with the original lessee, your lordship, Aloti. Your lordship, it is a Kalyani property. Your lordship, after that possession was handed over, but construction could not be made, your lordship, due to some valid reasons, your lordship, but they have sent one so cause notice terminating my plot. We have moved before the Honorable High Court, and Honorable High Court was pleased to direct us to allow us to construct the entire construct, your lordship, within 8 months, your lordship. But unfortunately, due to some your lordship, necessary permissions and sanctions, your lordship, that could not be done. But the construction was made within a limited stipulated time, your lordship. And after that, your lordship, we have sent the representation to them that the construction has been done. Kindly execute the lease deed in our favor. Your lordship, that has also not been considered. Your lordship, second round of litigation, we have moved before the Honorable High Court, and Honorable High Court was pleased to direct us, your lordship, pleased to direct them to execute the lease deed, your lordship, within a period of 2 months, your lordship. That has also not been done by them, your lordship. Now the original allotee, your lordship, made a will, your lordship, in favor of the petitioner. And your lordship, the petitioner has obtained the probate from the Honorable High Court. And after that, we have also sent one representation to them, your lordship, for kindly considering the my application, your lordship, for mutation. Your lordship, that has also not been considered, but they have issued one notice, your lordship, and that notice, your lordship, is challenged under this writ petition. Your lordship, kindly see page 65. Your lordship, they have rejected our prayer, your lordship, of the debt mutation, your lordship, because the lease deed, your lordship, was not executed. But your lordship, there was a specific direction, your lordship, for the execution of lease deed by the Honorable High Court. Kindly seize, your lordship, page 49. Your lordship, 9. Lordship, last para. For these reasons, I set aside the impugned notice dated January 6, 2005 and allow the writ petition. To this extent, I order that the respondent shall take all necessary steps for regularizing the allotment in favor of the petitioner, subject to compliance with all formalities and payment of all charges, if any, by the petitioner. The regularization process involving execution of the lease deed and deletion of the adverse remarks and observations regarding the plot shall be completed within 2 months. There shall be no order for cost in this case. And it is put on after that, your lordship. So there was a direction, your lordship, upon them, your lordship, to execute the lease deed.
Your lordship, kindly. Who is the petitioner before your lordship? Kindly see. Page 49. Let us come to first page 48. Page 48. Order of the Honorable Court. Sukesh Kumar Pal. Lord, kindly come to page 28.
This is Shukesh Ghosh.
Lordship,
Page
because
28. Page 1 minute.
lordship, no, lordship,
Page 28. My lord, your lordship, kindly see the allotment. Sukesh Kumar Pal, P4. Page 28. Sukesh Kumar Pal, your lordship got it. Then your lordship, kindly come to cost title. Sukesh Kumar Ghosh. Who is Sukesh Pal and who is Sukesh Ghosh? He is relying upon a document which is not relates to him.
He is not at all the
Lordship, may I submit, your lordship? Lordship, the writ petition was moved in second round of litigation by the Sukesh Kumar Pal, your lordship, and the direction was given, your lordship, to the concerned respondents to execute the send the draft lease deed, and your lordship, and for proceeding further, your lordship.
Agreement also, your lordship, kindly see page 23, Sukesh Kumar Pal.
Lordship,
Page 23, Sukesh Kumar Pal.
So initially it was Shukesh Kumar Pal.
Lordship, after that, lordship, after that, your lordship, the wheel was.
Sure.
Where is the probate?
Lordship, kindly seize. Lordship, kindly seize, your lordship, page 50, your lordship. That is the probate, your lordship. Annexure P13. Your lordship, Sukesh Ghosh is the person in whose favor, your lordship, will was given, your lordship, and he has obtained probate.
Yes, so that explains the situation.
Lordship,
Not the Kolani's land generally, lease deed is the primordial factor is that unless and until the lease deed is executed, the on whose.
Not complied with the order of the court, you have. not
Lordship,
executed
Not
the
that is
Lordship.
in favor of Sukesh Pal, my lord. Your lordship kindly see that.
Lordship,
Yes.
kindly see page 41.
Not executed the lease deed. In the meantime, Shukesh Pal died.
Lordship,
He had executed a will
Lordship,
and the will has been
Lordship.
probated.
Then I will come back with the
Your lordship,
instructions in this.
for my satisfaction, you will kindly seize your lordship page 41. Your lordship kindly seize 41. Your lordship kindly seize. Your lordship, this is the complete representation, your lordship, comprehensive, your lordship, and the Sukesh Paul has given your lordship the representation and the 42 page 42 last para, your lordship. Hence, construction of my one-storied building complete, and I prayed for registration. Unfortunately, I was given no response, your lordship. They are not responding, your lordship. For that, unfortunately, your lordship, will has been given done in favor of the petitioner, your lordship, and he has obtained probate, your lordship, from the Honorable High Court.
I'll file the report in this.
Let him come back with the report.
Lordship.
Right? It is submitted on behalf of the petitioner that the original lessee in respect of the plot in question executed a will in his favor, which was probated upon death of the lessee. Stepped into the shoes of the original lessee. Despite direction of this court, despite an order passed by this court on 23rd August 2006 in WP 4 in bracket W of 2005, directing the concerned authority to take necessary steps for regularizing the allotment in favor of the original lessee, subject to compliance with all formalities and payment of all charges, comma, if any by the lessee, by the lessee, include and execution of the lease deed. The deed was not executed. Stop. The lessee expired in the deed. The petitioner applied for mutation in respect of the plot, which was turned down by the authority by a letter issued on 25th January 2021. The said letter is assumed in the petition. Paragraph: learned counsel for the respondents seeks to submit a report in the form.
Report in the form.
Paragraph: let the matter appear under the same heading on 4th December.
Lordship.
What? 4 December.
Much great.
Mention that is done.
Much
Item 378, mention matters.
370.
I became the successful bidder in a process of my lord granting mining lease. A mining lease was granted, my lord, was executed, and on 21st November 2017. Thereafter, after 2 years, the possession certificate was issued.
The respondents, your opinion.
Blood, I am agreeing with you.
On my
With
lord,
Mr. Tarok Karan.
12th of
I am appearing with Mr. Tarok Karan.
12th of February 2019. And your lordship knows that your lordship judgment is there.
Is appearing for the mineral development?
Well,
Have
they
you
are,
served?
I have served. I
There is a service.
have come up with a very innocuous prayer, my lord. What happened in this matter, my lord?
Give me a minute.
My lord.
please.
He was here in the morning. Guys, কোথায় গেল?
কল্যাণী আর সল্টলেক একই 20,999 বছর ওইরকম ম্যাটার আমি প্রায় 1,000-1,500 করছি
Yes.
My lord, after my lord, getting the possession, the mining plot, when I went there, my lord, I found registers from the local people. On the ground, my lord, that they organized, my lord, prayer in the eve of Gajon. And my lord, they apprehended that if the mining activity starts, my lord, they might not be able to organize that. And my lord, thereafter, I gave a representation, my lord, to the district authority.
For alternative plot?
Lord?
For alternative?
No, my lord, for my lord, my lord, to resolve the issue so that I can carry out my mining activity. And my lord, I gave undertaking that during the April, May, my lord, they my lord, organized it fair, and I will not carry out any mining activity in the month of April and May. If your lordship kindly come to page 95, your lordship will find that, my lord, pursuant to the docket law, my lord, the thing was referred by the block land and reforms officer to the ADM. And your lordship will find that with this, the undersigned would like to inform you that the undersigned, along with Sri Rabindranath Pal, Amin, Sri Tapon Mahata, Amin, Sri Somnath Kolik, inquired critically in the field to see evidencing that no mining activity is running in the MGAR 8 and MGR sand blocks. Tonmoy Dal, authorized person of the list of such and such submitted to application, which sent for the end of perusal. My lord. That thereafter, my lord, a meeting my lord, pursuant to this, my lord, a meeting was organized. Page 103, your lordship will find several times the meeting organized, but 103, the meeting, my lord, was 103 page. The lordship will find that a meeting was held on, my lord, on 5th of September, my lord, on that day, my lord, and thereafter, my lord, your lordship will find in page 105, another hearing was fixed on 13th of October, and my lord, in page 105. And I attended, my lord, only one occasion I couldn't attend, my lord. But others, all the occasions, while they attended the meeting, and your lordship find in the next page, page 106, again the meeting was held. My lord, that is on 27th of 11. My lord,
Notices of
hearing, and I attended. Held. On one occasion, I couldn't, my lord, appear. I ventilated my reason of non-appearance. In other occasions, the meeting was held. But neither any decision has been, my lord, communicated to me, and nor, my lord, any steps have been taken so that it can be facilitated. Thereafter, my lord, gave a detailed representation that is in page 130. Your lordship will find that to take decision and to, my lord, resolve the problem, my lord, but 114, my lord. I can start at 114.
Yes.
My lord, no steps have been taken, and my last 4 years, my lord, despite of the payment of all the lease rental for executing mining lease, my lord, I am suffering. And my lord, no steps have been taken. And my lord, I am, my lord, giving the undertaking that, my lord, on my client, that there will be no mining activity in the month of April and May. My lord, thereafter, my lord, I think it should be facilitated, my lord, so that I can carry out my mining activity.
Yes.
My lord, taking the leave of my senior, my lord, may I submit, my lord? My lord, e-auction was held. Petitioner was participated. He was, he has come out as a L1 bidder. He has been given the position, but for a single day, he has started the mining, sand mining.
The reason why?
That he did not do the mining, but with now come up before the court, and the authority is concerned with some flimsy reason they have submitted. Time and again, the authority is concerned, asked them to appear before them. They in some of the meeting they have appeared, some of the meeting they did not appear. Now the period has almost elapsed. Now they have come up with a very innovative ideas that I could not do that because of the Gajon. The Gajon Utsav is held in a particular time, not for the whole of the year.
That is the petitioner's case also.
Yes, yes, yes. That's why the whole of the year, by law, the entire of the year, 360 days, he could have done this, barring the Gajon period, except in Gajon period, but they didn't do that. But they themselves did not, my lord, carry out the work of the mining after having received the L1, being a L1 bidder, and thereafter now they have come with a very, my lord, flimsy ground, my lord, that they now what they want is this, that for the 5 long years they haven't done the mining work. Now they have come with a plea. So give me some extension. In that period, I will do the mining. That cannot be. 2016 rule.
The petitioner's first prayer was to grant necessary assistance. Can you show me one
Yes, yes,
single
yes.
scrap of paper
Yes.
to suggest that you
It is
have
in the petition. They have got environmental clearance. They have got clearance from the local panchayat authority that their track will be.
It's not called assistance. He has stated that he faced resistance from local people and he sought assistance from.
I shall use affidavit, my lord, in
What
this
is-
regard. Yes,
what
but
is
kindly allow me to file affidavit.
Let them consider the report.
Or otherwise, let the DM consider his prayer.
Let the representation be considered by the DM.
For all these years, you have fixed.
Let the
certain
DM
dates for
consider.
hearing.
Your Lordship,
What
That's
is
why we have
the order?
called him time and again.
Yes, calling is not sufficient. Where is the order?
Hearing was
passed by
held.
you? Yes, where is the order passed by you? When a hearing is held by a government authority, an order has to be passed. Where is that order?
Order, my lord.
I find several hearings, but no order passed.
My lord, may I file the affidavit, my lord? I shall come up with all the orders and all the things.
By that time, my lord, that they will come with a plea that the lease period has been.
Affidavit is not required. Come back with a report in the form of an
My lord, may I
affidavit.
just,
Your Lordship,
my lord,
can
may I
send
just,
it to the DM for not the
What will happen,
consideration.
sir? Mr. Ganguly, you know what will happen if it is sent to the DM?
Then I'll come back with
The
the.
DM will only reject the application, that's all?
may I just indicate one page, my lord? Kindly come to page 100. But my lord, my learned friend is submitting, my lord, that as per your, this is the letter
Yes.
given to me, as per your representation, the block land and land defense officer sent reference mentioned report to the same, but it appears that you have not extracted any quantum of sand from your lease.
That's what we are saying.
Without mentioning any reason. And for inaction.
Same thing.
As a result, as such, you are directed to mention specific reason and the name of the persons who prevent you to extract the said land lease area.
Yes.
Thereafter, I replied to that.
Where is that reply?
Page 101. That has not been responded to, my lord, also. Unable to start, the local villagers or objection due to the religious and sentimental issue. And now they are taking the plea, my lord. It is within 2 months from the date of taking possession.
You have not replied to this also.
Lord, one thing, Your Lordship. Your Lordship, I am giving Lord 2 options. Either he can go before the DM, let the DM,
That will not serve the purpose.
then I'll come back with the
The
report.
DM will only reject.
Then
it,
I'll
that's
come
all.
back with the report in the form of an
The
appeal.
DM has all the powers to reject an application. He'll do that.
I'll come back with it.
We have given from the
We have
authorities
given
concerned.
ample opportunities. Only on the
Where are the
ground of not the Gajon and all, he has
You
not been
responded
going
to
for
this
that.
101.
Then I'll file the report, Lord,
You
in
have
the form of
not.
an appeal.
No step has been taken by the authority at all during the entire period.
5 years' time, he has not gone, he has not attended, despite
He has
following all
attended,
these
but where is
things.
the order, Mr. Ganguly?
Anyhow, Lord, I'll come back with the report.
After paying the lease rent, my lord, I sat tight, not wearing the stand. It is not my lord, fancy, my lord. It is the amount I paid.
Lord, may I take?
None appears for the third respondent despite service. Paragraph. It is submitted on behalf of the petitioner that despite being the highest bidder in an e-auction floated by the authority and execution of long-term mining lease in his favor, was unable to commence mining operation due to resistance offered by the local villagers. Stop. The petitioner approached the authority time and again, seeking assistance so that he could commence mining operation.
দেখ আমি ওখানে দেখে নিবো।
No response was received from the authority.
Lord, may I take leave, my lord?
Petitioner seeks necessary assistance from the authority so that he can commence and continue mining operation in the plot allotted in his favor, and also extension of the period of lease granted in his favor.
So your lordship kindly come,
Council. Yes.
kindly come to page 11, page 11, 11 district magistrate, page 100. District magistrate said you please show me the reason. Reason for which, explain the reason.
101, I've shown.
What is the reply to this letter?
In his reply only, he said, I have sent so many number of representation to you. That is not the reason. No.
He has stated that local villagers are objecting. Local villagers, he cannot name all the villagers of the village. Please come.
That's why he has to approach before the police or other authorities, my lord. At the Panchayat Pradhan given him the assurance that the sand carrying trucks and lorries are they
Responsibility after execution of the deed.
Yes, my lord. The Panchayat authorities, the police, the BL and LRO, all were ready to give him protection. But
Where is the document showing that all were ready to give protection?
my lord, may I come back with
Yes,
the, my lord?
come back with the report.
Yes,
Because I do not find anything in your favor in the writ petition.
my lord, my lord.
Learned Counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 5th December.
Kindly keep some interim protection so that in the
No.
meantime the lease period is over, they will come with a plea, my lord.
When
Lease
is the
period,
lease period over?
my lord, lease period, my lord, possession was given on 12th of February 2019. So your lordship, in the meantime, the lease 24, my lord, lease period stopped running,
December, come back on 5th December.
My lord.
This period is still there.
interim order, my lord,
Not necessary.
now, no, on that day, may I renew the prayer for interim order, is that day, my lord? the
I'm
situa-
not touching upon that interim order part at all.
That question is left.
Come back on the next date. If we can dispose it of, we'll dispose it of.
It is a 5th,
December.
my lord, great,
Please serve an advance copy.
my lord.
Next, 379.
My lord, in 379, may it please your lordship, I am appearing for the petition, my lord. I am led by Mr. Devajyoti Basu. Mr. Basu is appearing virtually, my lord.
Yes.
My lord, may I please your lordship?
For the respondents.
Well, I appear for the respondent ECL.
My lord, is your lordship, my lord, can I properly, my lord, am I properly?
Yes, you are audible. Give me a minute, please.
My lord.
You're for the ECL.
I appear for ECL, my lord, Eastern Coalfields.
What about the other? There are no other respondents. It's only the ECL.
Lord, there are, my lord,
Well,
State
the
of
other is-
Jharkhand, Miller State of Jharkhand, Director General of Mines, Dhanbad, Miller Chief Manager, Mugma area. I appear, my lord, for my lord, the General Manager, Eastern Coalfields, and
Respondent
his
numbers.
1 and 2, my lord,
You're appearing for 1 and 2.
1 and 2. 1 and 2, 1 to 6. I appear, my lord, for 1, 2, can't be, this can't be, 1 to 5.
1 to 6.
6 you can't be, you can't be.
Yes, you should be appearing for 1 to 6, isn't it?
Yes, 1 to 6, my lord.
What about 7, 8, and 9 served?
My lord, they are all served. My lord, may I say this? My lord, they are all served.
Actually,
Well,
that was
so
service.
The service would reflect, my lord, my juniors are there, my lord, they would hand over the service, affidavit of service.
Yeah.
My lord, I would be relying, my lord, so far as, my lord, these respondents are concerned,
Give me a minute, please. Give me a minute, please.
my lord.
It is the service of the Union of India.
My lord, Union of India,
These are
my
all
lord,
ECL. You have served only the ECL.
no, my lord,
State-
so far as, my lord, so far as, my lord, Union of India is, my lord, am I audible?
এই 6 টা আমি কি করে হব? If your lordship takes the cause title, I appear for 1 to 6. Service is some way, my lord, I also got.
7, 8, 9, I do not find.
I
service.
appear for 1 to 6. I appear, my lord. There is no no.
Well, so far as 8 and 9 concerned, well, my juniors are there, my lord, affidavit of
7,
service.
8 and 9 affidavit of service doesn't show service.
It would show service. Kindly have a check. I today I am on a virtual mode. That is why there is some difficulty for me. Otherwise, if I appear physically, if lordship fixes tomorrow.
Service is on ECL, but not on these.
I am for ECL, my lord. I am here.
It is also there. So far as the Director General of Mine Safety is concerned, and the state of Jharkhand service through the district magistrate. Those are all served. And they are not the affected party. The answering party is the Eastern Coalfield. And that is my other side also would be.
Have to be served, sir, even if they are not affected.
No, they are served. Kindly see. My
If your lordship kindly see, if your lordship, if your lordship kindly see, my lord, page number 3 of my affidavit of service, my lord.
Yes, page number 3.
My lord, serial number 6, my lord, serial number 6 is my lord, respondent number 8.
Serial number
I'm
6.
ECL 1 to 6.
No, this is served. 7 and 9.
Yes. 9 is also served. Kindly see.
My lord, Union of India, my lord, Eastern Coalfield is has my lord served one.
In that case, may I say this? May I say this? At our cost, we are not, we are deleting Union of India from the array of the parties. We actually intend to make Union of India who has to be represented through the Director General of Mine Safety, Dhanbad. Now, Director General of Mine Safety, Dhanbad is also made a party by his post. Well, lordship knows,
Lead Jharkhand also?
Yes, the state of Jharkhand is represented through the district magistrate, Dhanbad.
And service.
Mr. Thakkar appears, my lord, for state of Jharkhand. Mr. Thakkar appears, my lord.
My junior would show.
It's not there.
It is there,
7 and 9 are not served.
It is there, I have personally checked.
It is not there.
My lord, if your lordship kindly once again, my lord, come to my lord, page number 3 of my affidavit of service, my lord, serial number 7.
Yes, kindly see
this. Appear for a serve for the copy the AG.
The status
copy has been served.
My lord, serial number 7, my lord.
Serial number 7, yes.
Well, the additional advocate general,
signature is there. My lord, a signature is there, my lord. Just beside my lord, serial number 7.
No seal, no nothing. Please do not.
They do not provide any seal. They have provided the number.
I'm sorry, Mr. Basu, it's not served. Please come back.
But so far as they have the service is concerned, your lordship was inquiring that whether it is served or not. But we have made a.
It's not served.
It is not served.
But they have received the copy. Now, according to their system, I have inquired that from the DM office, Dhanbad, they only give me the receipt number, and the number is reflected. If lordship requires, lordship can direct an inquiry.
I cannot accept this service.
13746, my lord. This number is provided, my lord. This number, my lord, 13746.
There is the seal.
Seal.
There is someone representing Jharkhand in this court. Why
Yes, Mr. Thakkar, my lord. I say Mr. Thakkar, my lord, represent. He's the additional advocate general, my lord, Jharkhand. He is there, my lord. Mr. Thakkar.
Sorry.
My lord, if the office does not provide, my lord, any seal, my lord, while they accept the service on hand.
Since service upon.
My lord, may I say this in alternative?
Since sent through post.
Then,
service upon
may I say this in alternative, my lord?
Are not complete. Comma, let the matter stand over till.
Well, this is a very urgent matter. I am under threat. My livelihood is at stake. Kindly give me 2 days time. I will complete the service. I undertake. I will take my post.
After 2 days, I will not be there. Will it be all right if I fix a date? You can move some other bench. I should be candid.
Millard, may I say this? Millard, so far as this service upon DM Dhanbad is concerned, I must be very candid because I was personally inquiring also my junior's person that why there was no seal. Now I have personally told that I was told that from DM Dhanbad they do not trigger any system that to give the stamp. Now since lordship says that to send it by post. Yes. So far as Mr. Devnath is suggesting that Mr. Thakkar is appearing. So may I just request my juniors to serve a copy upon Mr. Thakkar and I would come back on Friday.
Friday not possible. I have just 2 more working days, so Friday will not be possible.
My lord, I would have to come back before your
Yes,
lordship.
my lord, there is a,
In that
there is
My
a,
lord, your lordship, my lord, at least your lordship is, my lord, curtailing my opportunity to address your
In
lordship.
that case, you can come back after vacation. If it is that urgent, I can fix a date. You can appear before some other bench.
No, my lord, only urgency, my lord, there is an absolute threat, my lord, of my lord.
Lord, the land is in Jharkhand, my lord.
Mines
Land
are
is
concerned,
not
the
allowed
mines cannot be workable. There
there.
is a
Jharkhand,
specific
226-2.
My lord, if Mr. Devnath says this, my lord, is unfounded submission, then I have every answer.
I have answered, Mr.
Mr.
Basu, don't
or
get
West
it. It's in
Bengal,
Jharkhand. I'm
whether,
making the point. It's a
yes,
Jharkhand
yes, I can answer to
And
Mr.
Millard, he
Devnath.
moved before, Millard, he moved. This is a residuary matter. He moved before the residuary
Yes,
court. Millard, there's an order.
this is a group one
Subsisting of a
matter.
land
This is
in
a mines
Bengal.
and
The
minerals
land
case.
in Jharkhand,
One
Chief
Mr.
Justice
Devnath
has
is
passed
saying,
an order.
Absolutely not, my lord.
I have the order. Without
Mr.
the order,
Devnath, as far as
Absolutely
concerned,
not.
suppresses and he
mines
moves.
and minerals
Each
case.
line is a suppression.
My lord,
তাও তো
My
এই
lord,
order
so
গুলো
far as, my lord,
সার্ভিসই
my
হয়,
lord, so far as,
সার্ভিস করবে না।
if your lordship kindly,
this is the problem with Mr. Devnath, my lord. In
Yes,
none of
yes.
the objection, he would allow the other side and he would make
The
all
order, kindly look at the order passed by this court. Kindly have a look at the order. He's saying urgency. He should have gone before the residuary bench. Grateful.
my lord, so
Your lordship has fixed the matter on
4th December.
my lord, kindly keep it on Monday. My lord, we would be under tiredness. My lord. Kindly keep it on Monday.
9th October. Amlan. 9th
Kindly keep it on 9th October. I'm grateful, lordship. I'm grateful.
Amlan. 10th October.
10th October.
My lord, 6th, 10th.
10th October.
I'm grateful, lordship. Deeply obliged.
Yes.
all right, may it please your
Next
lordship.
matter.
May it please your lordship.
I appeal for the KMD.
Very innocuous application, my lord. I think your
Then
lordship
talk
is
to us.
short. Your lordship need not open the fund. Now, the lease was granted in my favor by KMD authority.
Who is
on-
appealing for the state? You're appealing.
Well, I have subbed all.
Yes.
My lord, may I get back the affidavit of service, my lord, in item number?
What is that you have submitted?
My lord, on 10th of April 1989, my lord, the plot was leased out in my favor for a period of 999 years. As your lordship knows what normally happens.
Kollani property.
No, that
No,
is
no,
in
KMD's property.
KMD's property. KMD's property. My lord, the position was given to me in August 1990. Now, my lord, a nutrition certificate was issued in November 1991. But since then, of course, but I could not construct, as your lordship knows, your lordship will kindly come to the lease deed once at page 15. Running page 15, my lord. The first page itself, at the bottom, your lordship will find 5 or 6 lines from the bottom. Lease premium was 40,000.
Merited list question.
No,
His prayer is something
That's
else.
for the appraisal of your lordship. No, it's a very innocuous application otherwise. 40,000 blood I have paid for a period of 99 years. But what happened, then your lordship will kindly come to only few letters. It starts from at page 25. I'm not going to the merit, my friend is suggesting. Kindly come to page 25.
Yes.
But this is my letter dated
Session of time.
18th of July 2020, representation given. Then second reminder given 3rd May. You also will find at page 27. 3rd May 2023. Then, my lord, the notice was, hearing notice was issued on 23rd May 2023. I was asked to appear on a particular day, 24th of May. It should be written as April.
25th April.
It should be 25th May because the date will lordship will find 23rd May.
Yes, yes.
I believe it's a typographical mistake. And last line your lordship will find this is very urgent. Now, my lord, I attended the hearing. And then, my lord, no communication has been made to me till date. I made further representation at the last annexure at page 29. But I am only praying your lordship that at least I have the right to know the fate as to what happened as to the hearing. But nothing has been communicated to me. But this is my only innocuous prayer. Let them consider and pass a reasoned order.
Because I need to take instruction, whether
What instruction?
you may say what instruction, but I need instruction. Whether at all that hearing, what has happened, whether any order was passed
And the
on that day.
Consider the representation. Yes.
No, if there was hearing,
If not, because he says it has not been communicated.
Yes, but
oh,
I
he,
can't
he
say-
say, he says he attended the hearing. Hearing was, no order was communicated. So if there is an order, any order is passed, not communicated, let me take instruction and come back to you.
There should be an order to that effect.
Let there be an order by your lordship to that
Passed and
effect.
not communicated, let it be communicated.
I
No.
specifically stated that he
It-
attended the
As per
hearing.
his submission, my lord, that he attended the hearing, but subsequently he was not communicated anything.
There be a direction for communication, that's all.
That's all. That's all I want.
That is the prayer in the writ petition.
Yes.
That is the prayer. But on the face of it, if your lordship sees, my learned friend was placing the lease agreement. Lease was
I am
executed in
not arguing
1988.
that, man. Kindly do not do that. I am not arguing on that.
So as per
That may be a
clause,
next
so it
part
is
of
the
matter.
authority to take decision.
Authority has to take a decision.
He's
Yes.
waiting for your decision, he wants the decision to be communicated, that's all.
That's all. That's all.
My lord may dispose it of.
Can be disposed of.
Affidavit of service. The petitioner was granted
We have the right to online order rejected. Matter
Long-term
character
lease.
law means sorry.
by the Kolkata Metropolitan Development Authority for a period of, in short, KMDA bracketed, for a period of 99 years.
999.
999.
999 or 99.
As the Salt Lake properties are.
No.
999.
Huh?
See, for first page bottom. It's a virtual ownership. Now there are
999 years.
999, but clause 323 is
Yes.
there.
I am not pressing that at this stage, my lord.
We are not on merit and I am not.
A deed of lease dated 10th April 1989. Stop. Physical possession of the plot was made over to the petitioner on 6th August 1990 and 6th August 1990 and mutation certificate issued in his favor by the Kolkata Municipal Corporation. Kolkata Municipal Corporation, KMD Noy, on 11th November 1991. Stop. The petitioner was unable to raise construction in the plot in question due to various reasons for which the petitioner
Yes.
submitted representations before the concerned authority seeking extension of time to raise construction therein.
For the first time, Lordship, kindly add, for the first time in July 2020,
That I have shown to him.
at page 25.
I have already.
After the lease deed was executed in 1988, this is for the first time.
I have not concealed anything. I have not concealed.
On 18th July 2022 and 3rd
May.
May 2023 respectively. Stop. Pursuant thereto, stop for it. Pursuant thereto, comma, the petitioner was called for a hearing by the authority by a letter issued on 23rd May 2023. Stop. Learned counsel for the petitioner submits that though the petitioner attended the said hearing, comma, no further communication was made to him by the authority. Stop. The petitioner submitted a representation before the authority on 27 July 2023 requesting communication of the order passed by the authority in connection with the hearing held. Stop. The representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation and communicate the order passed by the authority to him at the earliest.
Kindly mark a reasoned order, kindly record a reasoned order.
Communicate the reasoned order password. Paragraph. Learned counsel for the respondents, for the learned counsel for the KMDA submits that, who should be the authority?
My lord.
Chief Executive Officer or the Special Secretary?
No, it was
Number 4, respondent number 4.
Deputy Secretary,
Deputy Secretary had called the
Deputy Secretary Estate,
court.
Respondent number 4.
Four.
To consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the fourth respondent to consider the representation submitted by the petitioner dated such and such and communicate the reasoned order passed by the authority with regard to the representations submitted by the petitioner earlier, earlier, within 2 weeks,
2 weeks, it may not be possible.
4 weeks. Within 4 weeks from the date of communication of this order. Disposal.
If not passed any such order.
Communication of the server copy, your lordship.
Lordship, permit the
There are
respondent to
authorities who do not accept the server copy.
Communicate the if any.
if not passed, order if not passed, Lordship, permit the respondent to pass a reason order.
No such order is passed.
Finally,
Respondent shall pass a reasoned order and communicate the same to the petitioner within the aforesaid time frame.
And Lord, they are obliged to do it with by the server copy. That your lordship will kindly add. Lord, certified copy নিয়ে এসো। I'm extremely.
So, my lord, in this matter, I beg to appear on behalf of the petition. So, my lord,
Sir, for the state.
my lord, this is the third round of litigation. So, my lord, this is the petitioner before your lordship, the private respondent lodged a complaint against the petitioner. Where, my lord, this is the sir, my learned friend is appear. Fine. So, my lord, this is the affidavit of service. So now, my lord, this is the third round of litigation. Now, my lord, this is straightway come to the page 63. I moved a writ petition. My lord, initially, my learned friend's client moved a writ petition before this honorable court division bench, and there was a direction to the authority concerned to consider his representation and pass a reason order. So now that is the problem, my lord, this the problem has arisen. Now I have come before this honorable court challenging the action of the authority concerned because of that, when a civil suit is pending between the same set of parties, so far the demarcation is flawed in question, that has to be considered by first authority concerned. So now, kindly come to page 63. There is, my lord, so many, my lord, the point of law is involved in this matter. My lord, the first submission before your lordship is the second param. Learned counsel for the petitioner had the submit that as follows. In 2016, petitioner number 2 made an application before the authority for returning the land which was acquired by the concerned authority in 2021. So my land has been, my lord, is the acquired, some portion has been kept vacant. So now that demarcation is questioned. That's why, my lord, I file a civil suit. So now second submission before the petitioner file a civil suit which is the parties to the demarcation. The very vital is the question of the demarcation. Though the private respondent has no right interest on that particular plot of land, because of that, several litigation pending before the petitioner and the private respondent in the family dispute or any other adjoining the property of the housing properties, and more than 3 kilometers far away, the private respondent residing there. There is no piece of land. So only, my lord, is the ego. They have filed an application and moved to an obtain an order. So now, submission before your lordship, there was a direction to authority concerned will consider the issue regarding the demarcation as well as the returning of the land.
So now this is very vital point, that point which has not been considered, another point. Now considering the same, in view of the same, the last para, page 65. Repetition is provided directing the authority during the hearing under section 10th, the authority shall be liberty to agitate all points, including the question of maintainability by survice of the civil suit. Now, I appear before the authority concerned. I ventilated the grievance. Kindly come to page 47. 47, 48, 49. Malada Sunani Somay Amar Boktobbo. So now everything has been ventilated that since the land is not, my lord, is that there is the dispute with regard to the demarcation. Whether the question arises, my lord, is the section 10(1). It's a very vital, my lord, is the no. If it is found, the law starts this provision is that if it is found the persons are occupying unauthorized, then he should.
Show me the schedule of the suit.
So no, I am coming, my lord. That is not, my lords. Now, kindly, my grievance is this, para 16 in my writ petition.
Yes.
Para 16, my lord, while passing the no copy of the inquiry report has been served. Because of that, this is the gross violation of peaceable natural justice. Because at that
10-3 order has been passed.
Lordship, I paper an appeal, pursuant to that appeal authority also not consider my grievance.
Appeal has been dismissed.
Disposed. My lord, this is the grievance this is the gross violation because of kindly see paragraph 16. No inquiry report. They have relied. It is the gross violation of peaceable and natural justice. Second, while pending disposal of the civil suit in respect of the demarcation, that is, my lord, this the plot number is, my plot is adjoining. That is, there is no dispute, the authority concerned held. That is the adjoining plot. I am coming the suit, my lord, the plaintiff of the suit. Second, my lord, is the considers of demarcation, the disputed land on the basis of the demarcation report, the concerned block land and reform officer, which is not only without authority of law, but also bad in law, but gross violation of principal natural justice. Because of that, my lord Justice, my lord, the Dipankar Datta holds the question of, my lord, the demarcation. The power has not been vested under the West Bengal Highways Act to the BLR. When it is the civil suit is still pending. I am coming, my lord, the judgment.
First and foremost, please show me the plaint of the civil suit.
Lots. That is the.
You annexed it to your writ petition?
Yes. Page 27. Maladista 27, Bimal Chakraborty, because of the other owner, the district magistrate, sub-divisional officer, assistant engineer, and BLRO. Block land and land officer, sergeant, my lord, all the respondent is made a party in there. So now the plot.
The private respondent was not a party to.
No, but because he had no right title.
It is pending.
Still pending. Malad is the private respondent has no right, title, interest above that particular plot of land, around 2 kilometers. Because of that, a several litigation is pending between the private respondent and the petitioner. That's why he has intentionally filed this application. Now, kindly come to my plot. The last para, appointed advocate commission for demarcation of plot and land. So now this the adjoining plot. I have given the details of page 33. 45, this on the west side. That is the schedule. So now, my submission before your lords is, when my Lord Justice Yoisendut was directed, another points. My land has been acquired by the authority concerned. I approach before the authority concerned. If you my lord, the acquired 18 decimal, you have used, my lord, this the 12 decimal. So why you have not returned the 6 decimal? That is page 37. That
been returned.
That has not been taken into consideration.
Till it is not returned, it is still government land acquired.
No, absolute correct. I am not on disputed that. But the question of demarcation, how much the authority concern has my lord taken the possession, so that is the civil suit has to be decided first. Not only that, my lord, is the consideration that every point has been taken in my appeal. Every point has been taken. My lord is the my lord is kindly come to ground, page 60.
Civil suit is in respect of 12 decimals and 23 decimals.
Lordships, absolutely, absolutely.
4690 and my lord,
4689.
Lordships, because of the adjoining.
4689.
I am not, my lord, there is no dispute that there is whether this the land is at all, my lord, is the government. I am in possession of that particular government land or not. That has to be adjudicated by the civil court. Now the BLRO, my lord, very vital point is this. Very vital point is this, my lords.
Civil suit is with regard to your own personal land,
Personal land adjoining, that is required for demarcation.
not the remaining part of the land.
No, that is the, my lord, is kindly schedule. Schedule, kindly see. Western Salem. My specific case is this. I am occupying the plot number 4690 and 4689. And adjoining plot of government land that is the recorded in west side. That is my plot of land which has been acquired by the government, 4591 and 4592. So now that is the, my lord, that is the demarcation is whether I am occupying the government land or the, my lord, my own land. That has to be, my lord, adjudicated by the civil court. Demarcation, the BLRO has no authority under the provision of the West Bengal Highway. Now, no more important, my lord, is kindly see when the section 10, one notice has been issued by the authority concerned and when the demarcation has been made. Page 45.
He challenged the order of the DM.
DM, I am coming. I mean, that.
What is the wrong in it?
10-4 order.
Yes, my lord. What is the wrong in it? He must show that.
My lord,
He's going to in another way, my lord.
no, I come before it's a non-application of mind. Non-application of mind because of that inquiry report, when a demarcation has been made, that report has relied. I have to serve before, my lord, the passing the final order.
That is the 10-1 notice.
My lord, I am coming, my lord. That is the my first agreement. Page,
My lord, he wanted to bypass
page
the
45.
original order.
Page 45.
He must show what is the wrong in it. He can't want to show that as because he has no case. My lord, he must show the order of the DM. What he challenged.
I am coming later on.
That is, my lord,
45.
that will solve the problem.
My lord is
Problem,
now, my lord, I'm now placing the order of the district magistrate. My lord is kindly see the district magistrate.
Take some more time.
My lord is that tomorrow is the date for my lord the demolition of the program.
Where is the
My lord, this is the I on my still, my lord, I got the information from my email.
Please show me the no email.
My lord, I will submit photocopy, my lord, in course of day. My lord, tomorrow is at 12:30, my lord, date for my lord the demolition.
May I just tell you, Lordship, your Lordship kindly see that all right, everything you are supplemental, you also kindly come to page 46 once. Page 46. আপনার আদেশ অনুযায়ী 15/2/2000 তারিখে সরজমিনের তদন্তের দিন নির্ধারিত করিয়া গত 8 তারিখ উভয় পক্ষে নোটিশ দেওয়ার ব্যবস্থা করা হয়। নির্ধারিত সময় বাদীপক্ষ দরখাস্তকারী ভবানী পাচ্ছেন মাই ক্লায়েন্ট এন্ড বিবাদী পক্ষ সুমিত চক্রবর্তী উপস্থিত সরজমিনের তদন্ত কাজ হয়। বিবাদী পক্ষ সুমিত চক্রবর্তী সরজমিনের তদন্তের হাজিরায় স্বাক্ষর করিতে অস্বীকার করে।
Yes.
He refused to, my lord, accept.
Admit it.
My lord, he has filed a suit on 2021. My lord, though this suit is barred under section 21 of the West Bengal Highway Act, even if, my lord, his suit is related to 469091. My lord, this suit property here is, well, I have the BLRO inquiry report, hearing report, everybody was served. Well, kindly see the BLRO inquiry report. My lord, he has been made a construction over the canal and one of the government property.
That is not the case.
But that is not the mention in the schedule of the property.
That is
My lord, that is the demarcation was made and my lord, the BLRO and encouragement was found.
that my lord is bypass.
My lord, I am coming.
Yes, to come.
I cannot continue today. Come back on the next.
My lord, this the kindly only, my lord, this for interim protection.
So, my lord, what
My lord, is
the
that then, my lord, is dismissed. Otherwise, my lord, tomorrow is, my lord, I am coming, my lord. There is the, my lord, is covered by judgment of the Honorable Justice Dipankar Datta. Only one judgment I am showing. There and the several judgment is there, my lords. Kindly one judgment before your lordship. Section 22 is the bar. I know. When but the my lord, this sir, my lord, there is.
4.92 is not the subject matter of the civil suit. And my lord, what is
My lord, is the kindly see. My lord, is the my lord.
Monday.
My lord, kindly.
My lord, the Monday in the mean. Monday I will come. Not only my lord. Tomorrow is the my lord. Tomorrow.
He has no
Demolition is the made. My lord, tomorrow is the day.
Please see that there is no demolition till the next week.
My lord,
My lord, I am ready. I
has
put
no
this
final
lots of
case at
judgment.
all.
Notice is on record.
My lord, I am giving my lord in course of day. My lord is kindly record the
My
submission.
lord, he has no challenge in the my lord, you will also kindly see 4, he has no prima facie case at all. 4592 is the my lord, subject matter. His suit is 4690.
Or adjoining.
My lord, kindly allow me. You have made my submission, kindly allow me. He has a two count. One is my lord.
Yes, my lord.
He has no prima facie case.
It's a WD road and that is not the case's landmark.
My lord, kindly see. My observation of the DM. My lord, the page 67. Kindly only one submission. My lord, page 67.
He refused to sign my lord the inquiry report.
My lord, page 67.
Same meeting on 9th October.
My lord, in the meantime, my lord, in the mean, my lord, then my lord, kindly dismiss the writ petition. Otherwise, my lord, tomorrow is the date. My lord, tomorrow is the date for my lord demolition. My lord,
No
my-
notice.
Please give
My lord, no notice was challenged.
my lord, only Monday. Up to Monday, I am not seeking.
No course steps be taken
My lord, you will also kind of.
in respect of the plot in question till the adjourned date.
My lord,
Get-
my lord, you
get
have no prima facie case. No, how can I go in order, my lord?
Next matter, my lord, next matter is very short, my lord. 2 minutes, but 2 minutes will take.
My lord, you also, he has not annexed the notice also, my lord.
383, Group 7 contempt.
এটাই তো মানে this matter just may I tell in a very nutshell, in earlier writ petition the petitioner was succeeded with regard to an order that has been obtained by him, that in a notified route there was one vacancy, and that vacancy are marked as 20 that vacancy are marked as 24th vacancy. Total number of permits 40, notified route maximum.
This matter has been heard and decided.
No, I am not on that. I am not I am not on just
Reiteration of facts will really not tell.
no.
Has it been complied with or not?
I am telling you, Lordship.
Further detail is required now.
Very good. Now, my lord, kindly consider, my lord, this is my affidavit. That what is, my lord, that this, no, the 2 pages affidavit. Lordship, kindly have a look. That 24th vacancy, that permit held already, my lord, before passing the order in the, my lord, the order passed in the first writ petition, that 24th vacancy was filled up. Then, my lord, second writ petition, my lord said that to comply with that earlier order passed by this court coordinate bench. Now, this step has been taken since it's a notified route, my lord, strength, my lord, limited 40 vacancy filled up. Now 24th vacancy. Now, my lord, a letter has been, my lord, written. If your lordship kindly, my lord, have a look at the, my lord, the yes, my lord, I have written a letter addressed to that particular, my lord, the permit holder, in whose favor that 24th vacancies permit was given, that, my lord, to show cause as to why, my lord, his permit should not be, my lord, the recall and or cancel, or it should not be surrendered. And this letter also, my lord, a copy forwarded to the, my lord, the applicant in the contempt application. Now, my lord, there are certain procedure under section 86 that permit is to be recalled. Before that, my lord, a show cause notice is to be issued. Then, my lord, that permit is to be cancelled. And, my lord, that vacancy, then, my lord, against that vacancy, my lord, the permit is to be given to the applicant, because number of permits are, my lord, the fixed up, my lord, the total 40, strength filled up. So this, my lord, the procedure, my lord, is below, it is late. It should have been followed much earlier. My lord, I would tell you, lordship.
So to shield the, let rule be issued.
No, my lord, may I tell? My lord, may I tell? The problem is that
Violation, blatant violation of the court's order.
my lord,
After everything, the authority chooses to issue a letter to the 24th permit holder, which was in violation of both the orders of the court.
the 24th vacancy already given to earlier.
When was it given?
My lord, that, my lord,
There was Justice Talukdar's order directing you not to allot that vacancy to anyone else but the petitioner. Subsequently, there was this court's order. So this is blatant violation of the court's order. Rule be issued.
then, my lord, then, my lord, may I tell one thing? Then, my lord, may I come back, lordship? Kindly give me one more chance.
Coming back, Mr.
No, may I tell? The whole thing is that he is,
The authority appears to be very adamant.
no, that is not. My lord, now the secretary or the, my lord, the board members, they were not there at that point of time. This secretary or the board members, my lord, they are not there at that point of time. Now, everybody is trying to comply with my lord's order. Now, if in this way, if it is not possible, then, my lord, naturally, my lord, it is up to them. Maybe then an excess permit may be given, because the only thing is to comply with my lord's order.
Will not be compliance of the order. I make it very clear. 24th vacancy has to be allotted to the petitioner. That is the only direction given.
But now, my lord, now the situation is that, now, lordship, kindly consider.
Existing vacancy, it's the order's court's order. Why show cause and all that was not necessary at all. In compliance with the order of the court, it had to be cancelled in one day and the next day it had to be issued, which has not been done. So this is blatant violation.
No, my lord, they thought, initially they thought it, but later, my lord, after a, my lord, may I tell?
Even they discussed with me also, my lord. I have to, my lord, very fair before your lordship.
How
Even now, my lord,
to allot
now,
the
my
24th
lord,
vacancy to the petitioner?
now, my lord, eventually it appears that,
How many days will you take to allot the 24th vacancy to the petitioner? There cannot be any other option.
my lord, may I tell before your lordship? My lord, in this letter, that's my lord, that's just my lord, I beg to your lordship. My lord, this letter, my lord, by 5th, so tomorrow is the 5th. Today is the 4th, tomorrow is the 5th. So lordship, kindly, my lord, fix it, my lord, next week, any day. I think, no, next week. And my lord, not,
Alleged container is saved because I.
no, then my lord, Friday,
Reopening. Yes. 17th November.
17th November. I think hopefully, my lord, I beseech your lordship.
Options. The alleged container has to give the 24th vacancy, not the 41st vacancy. The
My lord.
24th vacancy to the petitioner.
My lord.
Otherwise, he has to come with his baggage. He goes to jail directly from here. And that is an assurance from the court sitting.
I have followed. I have understood.
There is a limit to non-compliance. This is beyond that.
My lord, initially, my lord, may I tell, my lord, initially, my lord, even my lord, after the passing of my lord's last order, my lord, a threadbare discussion was held, my lord, that how to comply with. Now, my lord, they thought, my lord, may I tell you, they thought that at least, my lord, that the so-cause be issued and then otherwise he may come before the court. That is why, my lord, this procedure followed, otherwise not.
They have only not thought that it will be gross violation of the court's order. They have only not thought that. They have thought of everything else, which is meaningless. I have expressed my mind. Come back on the opening date.
My lord.
17th.
My lord.
Learned counsel for the alleged contender seeks an accommodation as a last chance to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on 17th.
My lord, কবে খুলছে আমাদের? খুলছে কবে?
Date, comma in default, rule will be issued positively.
My lord, 17th, my lord, I may not be available. 18th, lordship, on the, because on the,
It's a Saturday, I don't know.
oh, I see. Then, my lord,
No, we are open on that Saturday,
so
but still it is Monday.
Monday,
20th.
20th, great.
Next.
My lord, is there advocate on record? My lord, there is no need to talk any further, my lord.
Order was.
But I think, my lord, order should be complied with. Order should have been complied with. And my lord, it shall be complied. I beseech your lordship, my lord. On the next day, I think.
Next. 384.
My lord, there is no need to record that affidavit that I filed. No, there is no need.
Sir.
My lord.
384, my lord, I am for the petition.
Submitted report, my lord, lots of.
No, my lord, my lord, we don't want to file any exception, my lord. My lord,
They have already paid, fine penalty already paid. And they are now refunds of amount. That has to be clarified.
my lord, kindly takes up page 46, my lord, of the petition. My lord, although this has been heard previously, but it's a long time back, my lord. So, my lord, page 46, this is,
One thing is, can we conclude the hearing today?
yes, my lord. It will be over in
Matter.
very short matter.
Otherwise, it has to go to the other side of the vacation. That's why I'm asking.
My lord, my lord, it will be,
So that some motion can be discussed.
my lord, it will be over in 10 minutes, my lord. It will be over in 10 minutes. Only 3 pages needs to be considered. Only 3 pages of this petition.
Because I think Mr. Devra has to submit after that. Come back after vacation.
Some technical specification I have to explain before your lord, so otherwise.
My lord, anytime next week, my lord. Because my lord,
Yeah, if you're comfortable for some other bench, it's fine. I have a circuit bench from Monday.
my lord.
They're on the same heading. Fourth December. 4th December.
My lord, in November. My lord, we have already paid the amount, man.
29th November. Yes, you're seeking refund.
Man. We have for response number 2. 29.
29. Five.
Must say my application, madam.
Respondents, Mr. Debra?
29.
I have filed my supplementary affidavit as per your lordship directed me to submit
Supplementary.
affidavit. Your lordship wanted to see the earlier orders passed by the court, which had not been complied with. For consideration of the representation.
Mr. Dev, Mr. Debra, you have received this copy supplementary. Yes,
I got it. Well, I pray, my lord, the Bharata representation I made, let it be considered then.
What is the matter?
The petition before lordship, my lord, is an existing operator on the route, my lord, in between Burdwan to outskirts. My lord, the private respondents have been granted permit from Burdwan, Navavat to the outskirts. My lord, as per route alignment of the route, they have to initiate the journey from Burdwan. Instead of doing that, they are initiating journey from outskirts. My lord, our High Court has declared the law, my lord, to the effect that as per time permit condition, you have to operate.
There are several private respondents.
Private respondent, yes. Private
Served?
respondent.
All of them are
Yes, I
served?
have served. Served them, my lord. Well, that objection, my lord, page 30, and say P2.
Page 30.
Page 30. And say P2. Legal notice also sent, my lord, for consideration. And it's P32. Before coming to this court, my lord. Till then, my lord, it has not been considered.
This is against illegal operation of vehicles.
Illegal in that sense, my lord, not in compliance with route alignment. When you have been granted permit from Kolkata to Behala, you cannot operate vehicle from Behala to Kolkata. That's how High Division men said. That is the law declared by the division member.
Let this be considered.
That will be considered.
My lord.
Upon giving hearing to all the.
Oh, yes.
More time we require, my lord. What
Learned
Very
counsels for
sympathetic.
the parties. The petitioner. Is a holder of 3 permanent stage carriage permits in the route Ram to Navavat within bracket Burdwan. The petitioner seeks consideration of the objection filed by him before the authority for illegal and unauthorized operation of vehicles by respondent numbers 4 to 9 in the said route in violation of the permit granted to them. So the petition was filed by the petitioner on 7th December 2022, it is yet to be considered. The counsel for the state respondents submits that who should consider the board?
The board will consider. Board.
The
Second respondent.
consider the in accordance with law. Paragraph in view of the above, the petition is disposed of directly to the second respondent to consider the objection rather than no objection. That is objection. Consider and dispose of the objections submitted by the petitioner dated such and such. Within 6 weeks. Within 6 weeks from the date of publication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner and the private parties. Comma and accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner. Disposed of later.
I am for the petitioner in this matter, my lord. When the matter came up before your lordship on the earlier occasion, your lordship directed the respondent number 2, my lord, to file a report on affidavit, my lord. My lord, I have not yet received the affidavit, my lord.
No, just now I have received the instruction with the Milord circular, which says that it can be Milord reduced. The qualification can be reduced in second call, but in the form of report, it is not there.
Come back then. Because it has- And please serve an advance copy.
I'll serve it.
My lord, only one thing, my lord, I am praying before lordship, my lord. In the meantime, I will also submit an affidavit in exception to the report, my lord.
Learned counsel for the second respondent seeks extension of time to submit the report in the form of affidavit as sought. Paragraph. Care of the petitioner, liberty is granted to use an exception to the report, comma, if required. Paragraph, let the matter appear under the same heading on 4th December. Please serve an advance copy.
My lord, in this matter, my lord, service has not been completed, my lord, upon the private respondent.
Since service is not complete, comma, let the matter stand over till 5th December.
5th December.
Fifth December. Now, criminal matters are not ready.
We are mentioning that
3:30.
they have to go.
Election petition as well. কি করবো? উঠে যাবো? আবার আসবো। The pattern's ready? No. If you rise, I'll come back at 3:30. 34, court number 34 matters.
The matter there, leave was taken, my lord, for moving unlisted, my lord, today in the morning by Mr. Siddhartha Banerjee. the matter, my lord.
Yes, at the 2 PM matter আছে সেটা কোথায়?
একটা ম্যাটার ফিক্স করা হয়েছিল কিন্তু কোনো নাম্বার কিছু দিয়ে দেয়
Probably, my lord, the file has not come.
It's not giving anything.
কোনো কিছু সাপ্লাই হয়
My lord,
How can you expect?
আমি দেখলাম 10:40 বলছে আমি
My lord, there is a illegible copy annexed to the petition, my lord, there. That's why, my lord, in the,
You have taken necessary steps.
yes, my lord, I should, my lord. Now,
Come back to
it
me.
is,
It's no other alternative.
my lord, if it could be, my lord, taken up at 3:30, my lord, your lordship kindly.
This now you have not given the number. It's your fault, sir.
It was my, my lord.
You
I don't have any explanation to offer, my lord. I don't have any explanation to offer. It's
That's
my fault, my lord.
on this. Stop the demolition for some. I'll fix it tomorrow 10:30. Serve the other side and come back. কালকে 10:30 রাখুন, to be mentioned রাখুন।
My lord,
here and WP
my lord, that eviction will take place, my lord, that
group 1
Huh?
group 1 তো
group one.
One back. To be mentioned 10:30 রাখুন, give all the details immediately.
It's,
30 you move, sir. What
my lord, it is, my lord.
that means no urgency.
There is a urgency, my lord, but the eviction will take place at any point of time, my lord. There is a urgency, my lord. There's a grave urgency, my lord.
You're not bothered.
My lord, the illegible copy handed over by the client, my lord.
Has to be done, do it by this day. Serve a copy to the other side, the respondents, and come back at 10:30 tomorrow. Right?
Grateful, my lord. Great.
Serve the other side, please.
I shall, my lord. Sure.